The meeting, I mean.
So there it is, and then you would just click on it, right?
Yep, click on it. And then it says, move to meeting, organizer.
I would just say,
No, and I haven't talked to them, and I meant to check in with them, but things have
You
been
just
nonstop.
click on that, right?
If you're working at their office, you know. you'll see it.
Yeah.
So,
So, yeah, no, I mean, I think he's getting busier. I think, I mean, I have to leave in my job. I don't know
why it's moving like this.
Yeah, that's why that thing came up, I think.
yeah, he's a good guy, hopefully, you know,
I know, I really like that.
so do I.
Because when we first moved in,
I don't know what to do with them.
Yeah, there's someone on that called in, the number ending 6031.
Yeah.
We hear you. Hello.
Okay.
Jill, we're ready.
Yeah.
So, you know, we're gonna start this meeting, okay? Because,
Say that again?
we're gonna start this meeting.
Okay, thank you.
Did everybody hear? I have two.
Yes, we heard.
Okay, so, we're gonna have quiet in the room, and because there's a little, did you hear that feedback?
Yeah.
Just a tiny bit of echo.
I would mute yours and you should talk loud and it'll come here. No, mute your Zoom.
I needed my computer.
Mute your Zoom, but keep your computer up. Because the computer is going through your earbuds.
Yeah, okay.
Let me see.
I got it. But I'm gonna keep it up so when I do need to be on there, I can.
Yeah, keep your volume, you'll hear it from here. Other people.
Can the people online hear me?
Yes.
Good,
Yes.
okay. Okay. Welcome to the Zoning Commission. This is a regular meeting on September 1st, 2020. This is a public hearing on Tuesday, 6:30 we were starting. This is a via teleconference. We're going to receive public comments. This isn't the agenda.
That's legal notice.
Yeah. I'm reading like this doesn't look right.
I'm sorry to interrupt, but can you keep your voice up? It's getting very low.
Talk loud.
Jill,
Sure.
get closer to the mic or something.
You're not using those microphones then, are you? Does it?
That's not going to pick up on this.
Okay.
You can try.
Should I? Is this better?
Yes.
Carl, is that better?
Yes.
Okay, so the Town of Somers Zoning Commission meeting on Tuesday, September 1st, 2020, 6:30 here at the Town Hall. This is a teleconference meeting. To join this meeting and speak during the public hearing, we had a dial-up number 1-646-558-8656. The meeting ID number is 850-1007-1046. The passcode 754847. Members present here, myself, Jill Conklin, Phil Shapiro. Members present online. We'll do a little roll call here if you want to unmute yourself. I see Dan Ferrero,
Carl Walton is here.
Carl Walton,
Paige Radford is here.
Paige is here.
Lucas Gary is here.
Hey, Lucas.
And Loud.
Okay. I will say
John Sanford is here.
Tom Sanford.
Yes.
Hi, Tom.
Member of the public, I believe.
I think so. Yeah. So, moving right along, we have a public hearing tonight. It's, we have three public hearings. Are we taking these all separately? Or,
Yes.
yes? Okay, so I'm gonna read in.
Dwight says no.
Dwight says no. Okay, so,
You,
let's
for the
vote
record,
on
Carl
that.
Antolini, you can open the public hearing on all three applications at one time and have a consolidated public hearing.
Thank you for that.
Sounds good.
So I'm going to read the legal notice in. The Town of Somers Zoning Commission will hold a public hearing on Tuesday, September 1st, 2020 at 6:30 p.m. via teleconferencing to receive public comments on the following. Like I said, there's 3 different applications. The first one is number 20-009, Amy Eastman, 40 Hallie Lane, Somers, pursuant to Article 12, Earth Removal and Filling, Section 214-17, an issuance of a special use permit application is seeking a special use permit to undertake excavation, removal, and filling of approximately 9,650 cubic yards and remove that material to the abutting conjoined parcel at 42 Hallie Lane. That's the first one. So Carl, Landolino, did you want me to read all these in right now? And then we'll take them one at a time? Thank you. The second one is application number 20-010, Amy Eastman, 40 Hallie Lane. I'm getting confused with all the feedback.
Right, 1 second.
Because there's 2 mics too close to
It
each
is,
other.
I know.
Something changed.
Well,
1 minute.
we're getting John Parks up and running. So the second application was number 20-010, Amy Eastman, 40 Hallie Lane, Somers, Connecticut. A zone change from a residential A zone to a residential A1 zone for a portion of the conjoined parcel at 42 Hallie Lane. The third one, application number 20-011, Amy Eastman, 40 Hallie Lane, Somers, Connecticut, pursuant to Article 12, Earth Removal and Filling, Section 214-70, an issuance of a special use permit. The applicant is seeking a special use permit to undertake excavation, removal, and filling of approximately 9,650 cubic yards and remove that material to the abutting conjoined parcel at 42 Hallie Lane. These applications are on file in the Land Use Office of the Town of Somers, Somers Town Hall, or on the website www.somersct.gov. At this hearing, interested persons can be heard, written communication received. To join the public hearing, I already went over the numbers, the meeting ID number, the passcode. We do have people here in person too. This was dated Somers, Connecticut, the 13th day of August 2020. This was published August 21st and August 28th, 2020. So I'm sure the applicant is going to want to address us.
Yes, Madam Chair. My name is Dwight Merriam. I'm the lawyer for the applicant, Amy Eastman. I reside at my office is at 80 Latimer Lane in Simsbury, Connecticut. As was explained, this is a single public hearing on 3 applications. And after the hearing closes, as I discussed in a memorandum that I provided to the Commission, the Commission will deliberate separately on each of the 3 applications, one after the other. The first application we call SUP-1. It's the one continued from your last meeting. Then the rezoning application is the next one. And then the last one is the Special Use Permit 2, we call it, which allows the removal of excess rock from 40 Hallie Lane over to what was 42 Hallie Lane, and the bringing in of 2,500 cubic yards of fill to finish the lawn. Now, I know that most of the commissioners, if not all, have visited the site, so you have a sense of what that site's like today. I also hope that you've all read my 17-page memorandum, which explains in detail, have you, Madam Chair, did you? I assume the commissioners saw it. I asked Jen Roy to make sure the commissioners saw it.
I wasn't able to get through 17 pages.
It's 17 pages, so I'm sorry, but, you should have full sets of the plans, is that correct?
Correct.
Okay, good. So that'll make it easier for those who are with me. And with me this evening, you see John Parks is there in the room, and Jay Ussery is with us, who's the project manager. And this evening, a new face, Ashley Sullivan, a professional engineer, who's going to speak to the issue of well testing, which is a remaining issue on the first application, SUP-1. Since I provided a detailed memorandum
Excuse me, Dwight.
all of the points...
Dwight, Jennifer
Yes.
Roy for the record. Can you please refer to them as application number 20-009?
Yes, I will.
That way, because when you're saying 1, 2, and 3, it doesn't coincide with what all of our documents are labeled.
Or even the
Sorry,
last
that's what I
one.
haven't called for shorthand, but
Excuse me
009
minute,
is the one
one
that's
minute.
continued to tonight.
Could we, maybe you could just use the last 3 digits.
That's fine.
009,
I will.
010, but the audience, the live audience here
I'll turn it up as
is
best I
having
can.
trouble
but-
hearing, so,
Okay, I'll turn it up. There we go.
Well, I'll turn it up a little bit too.
Thank you, Dwight.
I'll use my Navy captain voice.
There you go.
So 009 is the continuation of the special use permit application that you heard most of the hearing already. And 010 is the rezoning, and 011 is the second special use permit. Let me start off with 009.
Can't hear you.
I'm going to ask Jay Ussery in a moment.
excuse
It's a
me one
caller.
minute. Who is
It's
it that
just a random
can't hear?
person.
Hello, no sound.
Then you have muted yourself. I mean, you have
He's on a
done something,
telephone.
because you're on a telephone.
Oh, my God.
Well, we're gonna continue.
I'm going to ask Jay Ussery in a moment to speak to a couple of things that needed to be addressed. The depths of the water table and the bond. All of the other issues that were brought up at the commencement of the hearing are addressed point by point in that memorandum. And I can go through them with you if you wish, if you haven't read it. But if you've read it, it would not be worthwhile for me to take the time to go through one by one. But basically, we've addressed all of the concerns in writing and addressed them completely. We do have these couple of issues about depth to the water table and the bond, and all that's covered in a checklist that was included and posted on site as well. I did raise a question, I will say in passing, about the photographs that were put in. There was a photograph taken, there were 2 sets of photographs put in. Most recently, 5 Google Earth photographs were offered by someone in the town. We have no objection to those. Those are fine. We know where they come from. They come from Google Earth. They were asked to be made a part of the record. We have no objection to that. But the other photographs that Attorney Famigliani put in at the commencement of the hearing was an overflight photograph of some type and a photograph taken from the edge of the site. I requested the name of who took the photograph. It was allegedly taken by a pilot in an aircraft. No one's been able to tell me who the pilot was, who the photographer was, and who the person was that received those photographs. And that's sort of basic information that's normally required to put something in the record. We believe those photographs may have been taken by a trespassing drone. And until we know who took them, I must object to their being in the record. I hope they would have been withdrawn by the Clarks, but they haven't withdrawn them. It's not a decision for the commission to make now. The strict rules of evidence don't apply to zoning commissions. I know that. I work in that field, so I know. We put newspaper articles in and all kinds of things. But with this information, at the very least, we should know who took the photograph and where they came from. So we don't have it. I just ask that the commission consider that during its deliberations on 009 as to whether it's proper to have photographs in the record of that type. So with that, I'll turn to Jay and ask him to speak to the depth of water table, the bond amount, and anything else you need to touch on, Jay. And then I'm going to go over to Ashley Sullivan, because there is a request by the Clarks to undertake well testing. And we don't believe that well testing is indicated in any way whatsoever. And I'll address that momentarily when Jay finishes on those points. Jay?
Good evening. For the record, Jay Ursery with J.R. Russo and Associates here representing Amy Easton with regard to these three applications that you have before you this evening. 009, which is the first app, which we're talking about now, 40 Halley Lane, is essentially the house lot. And I can pull a plan up here, and I'm going to do my best to share my screen with you to see if we can work through this. Just give me a second. And
I actually made a couple of copies.
Okay, can everybody
of the
see
report,
that?
not of all the maps
If you want
that
to
have
come
been on the
back here
website.
and see what you're welcome to come back here and sit.
Yes, I can see it.
Okay, so for those of you who are online on Zoom, I think you can see this. And let me go down and we'll start at the street. You can see, and hopefully you can see my cursor as I'm working this around the plan.
Yeah.
Here's the cul-de-sac at Halley Lane, and we have a driveway that winds up the hill towards the Eastman's home that's located here, and a driveway and a garage in this area. And up above this, you'll see this cross-hatched area here. And that's the area where the excavation will take place at 40 Halley. As the memo says that was submitted by Attorney Eastman, we're looking at about 9,650 cubic yards of rock that will be removed from this area and hopefully be moved to the rear of the property on 40 and 42 for the conjoined parcels, as the Attorney Merriam had said. The parcels and the reconfiguration has been approved by planning, and these parcels actually are now merged. But this area is the area of the rock removal, and we went over this the last time, and it's fairly small in size. It's only just a little bit over a half an acre in total, and the total depth of excavation at the deepest point here is about 20 feet. So we're taking about 20 feet off, bringing it down to the elevation of the lawn that's around it. And those commissioners who went on one of the site walks will remember what this looked like as we kind of walked around this, around the house and the lawn area, to show how this would come down to the lawn grade if the work is approved. So with regards to water table, your regulations require that we have a minimum of 5 feet between the finished grade here and the water table. And in this particular case, the Eastman's well, which is located over here in front of their house, right where my cursor is now, their well happens to be 460 feet deep. So that said, certainly the water table is much deeper than 5 feet below our excavation. And if we were to assume that maybe there's 100 feet of water within that well, and the static level is maybe 360 feet, and we're taking 20 feet off, that tells me that we're in excess of 300 feet to the water table. Now, we've also looked at the neighbors' wells, because maybe that's a concern, and we're going to talk a little bit more about that later on. But I've also got a plan here that I've got up now that shows the neighboring wells. And again, if you look at my cursor, here's the Eastman home, the area that we're talking about excavating here. And there's this line that kind of goes around the entire area here. If you're following my cursor, you can kind of see it. And that's a radius that's 500 feet distant from the area of the excavation. And the reason that it's 500 feet is because in the memorandum from the Connecticut Department of Energy and Environmental Protection, they talk about we should be concerned if we're blasting about wells that are maybe within 500 feet. Well, as you can see, if you look at this, there really aren't any in this, except for maybe one that's located right here. It's just about on the 500-foot line. But the reason I'm talking about these wells is they're much lower in elevation than our site, and on average between 30 to 50 feet lower at ground. That's ground to ground. So again, if we start looking at water table and depth from finished grade to the water table, even if we look at the neighbors' wells, we're hundreds of feet, way more than 5 feet, which is what's required in your regulations. So I wanted to talk about that just a little bit. So there's no issue, at least in our eyes, with regard to this application with finished grade to water table, meeting your minimum 5-foot criteria, and what we're telling you is we have hundreds of feet from our finished grade to the water table of our well or any of the neighbors' wells. So at that point now, I'm going to go back to the 40 Halley Lane plan. And bear with me here a minute. This is back to where we started. And let's talk a little bit about bonding. In your regulations, we're required to provide a bond with a sand and gravel removal operation, which isn't really what this is, but that's what we're submitting under, so let's talk about it. And it says that we have to provide an amount to the town satisfactory to take care of soil and erosion controls and essentially restoration, so it's what we call an S&E bond. In this particular case, we've put a number together which essentially lumps together two applications, 009 and 0011. Because should this all be approved, that's the total area that we'll be working in. And so what we looked at is we looked at full replacement of all the soil and erosion control measures. Now, for those of you who were up there, you noted that the soil and erosion control, silt fence, is already in place. It's already there. However, we included the full cost to replace it all. We also included in that cost the dollar amount to truck in 2,500 yards of topsoil, the cost to spread the topsoil, and also the cost to seed, fertilizer, and mulch all that topsoil. So when we add all those numbers together, we're at about $97,000 or $98,000, if I remember correctly. And it's in Dwight's memo. So we're just under $100,000, and we'll add a contingency to that. We'll be a little over $100,000. And that's something that, at the end of the day, should this all get approved, your town engineer, Jeff Ford, is going to review that. And typically, we might go back and forth a little bit. Jeff might say, well, you need to add a little here, you may be a little heavy there, but we'll come up with a number, and at the end of the day, that number is going to be about $100,000, maybe a little bit more. And that's what we're proposing, and that's what's in your memorandum that you have before you this evening with regard to this application. So, in terms of 009, there's a number of things in your site plan requirements and in your approval criteria for a special permit for this use. And I basically walked you through all of those at the last meeting. I'm going to give you kind of a broad overview of this right now with regard to essentially 009 and 11, which are the two special use permits for the excavation and moving of this material around, if you will, under the regulation. So the way your reg is put together, there's a lot of criteria in there, and a lot of it relates to, in fact, most of it relates to sand and gravel operations, where somebody's going to go in and they're going to remove material, they may screen it, they're going to load it in a truck, and they're going to haul it away, and they're going to sell it to somebody else. Well, that's not what we're doing here. There's no material that's going to be removed from this site. We're going to move it from one part of the site to another part of the site. So, should this all be approved, what will happen is, and again, those of you who came on the site walk with us, you came up a gravel access driveway, and I'm going to go to a different plan here so we can take a look at that. And hopefully you're all able to see this, and we'll start here. We came up a gravel access driveway that is on the Fiore property to the north and the east of the excavation area. And that's located right here where my cursor is on Mountain Road. And the Eastmans have an easement over this for access to their property. And it's an existing gravel drive that was there when the Eastmans bought the land, and they've been using it. And what would happen here is there would be some construction equipment to come in to start this project. There'd be an excavator, there'd be a loader, there'd be a track drill, there would probably be a dump truck, and that equipment would come in one time. It would come in and it wouldn't leave there until this project is over. And we're talking about a total project duration here, if this were to be approved tonight, that might start in sometime in September and would be completed before the end of the year. So the equipment's going to come in, it's going to come in this driveway that, if you follow my cursor, and it's going to come up and it's going to come onto the site on an existing roadway, and we're going to come around and we're going to come over into this area. And we're going to remove some rock here by hydraulic methodology. There will be no blasting, which is in the memo if you've all read it. And we're going to take it and we're going to place it in this area down here. So that's going to take place over probably about 60 days, maybe 90 days. And again, we're pretty confident we'll be done before the end of the year. And one of the things that came up when we talked about this, and Attorney Famiglietti asked a very good question, is that in your regulations it says that we cannot excavate or place material within 100 feet of an abutter. Well, Attorney Famiglietti is representing the Clarks, and they're over here. And they're not actually in a butter because Fiore owns a piece in between, but we respect the regulation and we understand what the meaning of the regulation is, and we've kept all of our material and regrading more than 100 feet from the Clark's property. So we are 100 feet away, in fact, a little bit more than 100 feet away. And that was a very good question, and in fact, when we first started designing this, it was one of the things in the office that Tim Kuhn, my partner, and I talked about, said, well, they're not really a butter. It doesn't really require it. That's not what the regulation said. I said, but no, we really should stay 100 feet away. And there's no sense. We've got plenty of room here, and we can move it back a little bit, and we can meet that criteria, and we've done that. So that's kind of a basic overview of what's going to happen in terms of the material being excavated and moved. It's essentially going to leave this area here where my cursor is and move to the rear, and it's going to be put over here. And for those of you who went on the site walk, you saw that. We talked about it, and it's probably about 500 or 600 feet away, if I had to guess. I'm not sure exactly, but somewhere in that neighborhood, and it's a simple movement of material. No material is going to leave the site. During the time that is being accomplished, and this is really what relates to application 0011, is we're going to need to bring in some topsoil, about 2,500 yards, which is roughly maybe 120 truckloads, because there's not much topsoil here. We've saved everything that we could. The topsoil depths up here in the wooded areas and the ledgy areas average from about 0 to maybe 4 or 5 inches, and that's not really enough to grow good grass, and that's what the Eastmans want to do. They want to create a nice backyard for their families where they can go out and enjoy some active recreation with their kids, whether it be soccer, whether it might be football or baseball or whatever. They don't have much of a backyard. They have very little backyard at all when they first bought this, almost nothing. Hence the pool over on the side of the house over here and not behind the house, because there was no place to put behind the house. So when that material comes in, it'll probably take about 30 days or so. It's not going to come in one truck right after another, 120 trips in a day or 2 days. It's going to take place probably over a month with a few trips every day, and the material will be brought in so that they can spread it and grow grass on the area once the excavation and the grading is completed. So that's kind of a broad overview of really what's going to happen here. The majority of the areas that are going to be cleared are already done. There's a very small amount of clearing that's going to take place out here near the northeast corner. That's really the only area. It's probably less than 1/10 of an acre in size, and there will be a small relocation or a slight relocation of the east to one of the gravel roadways that's there to create access to get back and forth. And those roadways will stay in place once this work is complete. So with regard to, and I've kind of drifted off base here a little bit, with application 009, that's kind of where we are in terms of this. And I'm not going to go through all of the criteria. I did it the last time. It's our opinion that we meet all the criteria in your gravel removal excavation section, even though that's really not what we're doing, but we believe we meet it. And I think at this time, probably, Dwight, maybe we want to have some discussion with OTO about the wells and the reports that came through Steve Jacobs' office, I guess, in terms of testing and so forth. So I think probably we want to go there now. If there's any questions with regard to 009 as we move on further, I can answer them for you as we move forward.
Jay, this is
Yes.
Carl Landolina. We haven't talked about the zone change, and I'm sure you're going to get to that, but while you have this map up, can you show the boundaries of new 40 and then the area that's proposed for the zone change inside?
Let me go to the zone change map, Carl.
Will that have these working areas in there on those as well, or is that?
Let's take a look. No, it does not. So let me go to the overall site plan.
I just want people to understand.
Yep. Let's take a look at this. So application number 10 is an application for zone change. And essentially what we're doing is we are going to extend the, and I can't read this very well at this scale, the house lot zone, which is, and I don't want to follow this up, which is A1. And we want to continue that zone to the rear here, so that the area that we're working in back here also becomes in the A1 zone.
Mm-hmm.
And that's required in your regulation, because your regulations say that gravel removal operations are only allowed within your A1 zone and not in the A zone. So if we look at the overall plan here, this cross-hatched area is the area of excavation, and the proposed zone line starts here where my cursor is, and hopefully you can all see it. And this is at what was the northeast corner of 40 Alley, and it moves northerly out to the Fiore property line, and then it goes westerly again over to the Fiore property line, comes back southwesterly to some extent along Fiore, and then goes southeasterly back to the original north property line of number 40 Alley. So this is the area that's proposed for the zone change, and it's about, I'll have to go back to the other map, but I want to say it's about 5 acres.
It is 5.45 to be exact.
5.45 acres. The area of the reconfiguration includes more land than that. It actually goes all the way over here to the east and then off back to the west. So all of this area now becomes part of 40 Alley, and the zone change itself includes roughly 5.5 acres of that particular area that will go to the A1 zone. So it's an extension northerly of the A1 zone from the current 40 Alley Lane property. So, and that was a good point. So without that, we don't meet the regulation, and that's the reason for it, because your regulations say that our sand and gravel and removal operations have to take place within the A1 zone. So that kind of shows you where that is. So I think at this point maybe we'll go to Ashley and
Let me jump in here, Jay. Thank you.
Go ahead.
Miriam speaking. And Jay, I'm glad you went the direction you went, because you just covered nearly all of my windy memo. Only a surveyor could do to a lawyer, so thank you. And you did it very well. And the one thing I need to point out on the rezoning, just so everybody understands, the area of the boundary change is about 9 acres. But we did it that way in order to have a regular shape. So even though the boundary change adds 9 acres to 40 Halley Lane, the rezoning is only about 5.5 acres. The Planning Commission approved that boundary line adjustment unanimously. They also, as you know previously, unanimously recommended 009, the special use permit, and at the same time they approved the boundary line change. They unanimously recommended the rezoning and the special use permit 011. That's from the Planning Commission. I'll come back to the access road issue that Jay so ably covered generally, to give you a couple of points from our perspective as to why it's entirely proper and called for to use the mountain road access. But we also had questions raised by some of the neighbors concerned about radon and uranium in their wells, and asking for potentially some well testing. As Jay pointed out, the DEP guidance is oriented principally to blasting. And although we originally applied for blasting, the applicant did, we withdrew that, largely to meet the neighbors' concerns. The neighbors had also displeased with the jackhammering that was on the site previously, and we're not going to do that either. Instead, we're going to continue with this operation of drilling and hydraulically fracturing, which is drilling holes down through the rock, inserting a device, a closed circuit device, that hydraulically pushes the rock apart. It is the best operation that you could have in terms of protecting the neighborhood. Just want to read you a few sentences from some of the literature of the companies that have developed this interesting and important technology. It's a lot more expensive to do it this way. This is going to cost more than $100,000 more to use the hydraulic fracturing technique than the blasting or jackhammering. And it's going to take longer. I'm going to tell you a little bit about the time periods that we recommend to the Commission, and that the Commission imposes on Amy Eastman as part of her applications. But here's what one of the manufacturers of the device says. Blasting and hydraulic hammering are becoming more regulated due to safety concerns and the general public becoming more wary of these methods. Complaints from nearby residences, offices, and/or medical facilities are often enough to seriously impede or terminate the project activities. Hydraulic rock splitting avoids the problems and setbacks, which is what Ashley Sullivan's going to talk to as well, avoids the problems of setbacks incurred using blasting or hydraulic hammers. Due to the operating principles, the Darda hydraulic splitters are the safest way to dismantle rock. Operation of these tools produces no fly rock, no shock wave, no audible explosions, and no vibrations. And the town attorney and the zoning enforcement officer have observed this drilling and hydraulic splitting of the rock in person, and have observed that it cannot be detected off-site. It will have no impact on the neighbors, and therefore that's why we don't think any well testing is called for, particularly since it's usually only called for blasting. We went back to OTA and asked them to take a look at this issue. O'Reilly, Talbot, and Oakham are experts in this area, and we've worked with Michael Talbot before, back when there were these claims of uranium and radon occurring in the wells, which is, as you'll hear momentarily, a natural occurrence, was not caused by the Eastmans in any way, and are not implicated in any way whatsoever in any way whatsoever with the hydraulic splitting of this rock. So we have here a letter today from Michael Talbot, who has to be in another meeting, and we're going to read that into the record here momentarily. He's a professional engineer and principal at O'Reilly Talbot in Oakland, a geotechnical engineering specialist with experience in groundwater contamination studies, environmental site assessments, and remedial engineering. He was previously with J.H. Keinfelder and Associates in California, Louis Berger and Associates in New Jersey. He's an active member of the American Society of Civil Engineers and past president of the Connecticut Division. He has a Master's of Science in Civil Engineering with a specialty in geotechnical engineering, University of California, Berkeley, and a BS in Civil Engineering from Merrimack College. And he was the principal author, but two other principals have signed off on this letter, the opinion letter that we're going to present to you. And we're very fortunate to have Ashley Sullivan here this evening, a professional engineer licensed in Massachusetts, Connecticut, and Rhode Island with experience in contaminated soil and groundwater assessments, as well as environmental and geotechnical engineering design and construction monitoring. Ashley Sullivan specializes in geotechnical services, including the design of shallow, intermediate, and deep foundation systems, temporary earth support systems, basements and retaining walls, pavements and earthworks, and construction and seismic considerations, which, when it comes to blasting, are important. Ashley has also performed geotechnical evaluations and developed repair recommendations for building settlement, slope instability, pavement failures, and small to intermediate-sized dams. She has a BS in engineering from the University of Massachusetts at Amherst, go UMass.
Right.
And an MS in environmental engineering from the University of Massachusetts at Amherst. So, Ms. Sullivan, thank you so much for being here this evening as Michael Talbot's surrogate for the next couple of hours. And if you could go over his work and that of your firm, OTA, and their opinions on the radon issue, the uranium, the hydraulic splitting of this rock, and the lack of any indication whatsoever for this one well that's 498 feet, more or less, which does not need to be tested before or after. Sullivan.
Thank you. Glad I could jump in and for Mike Talbot tonight. So what I have been asked to do is read a letter that was generated in the past few days as Mike Talbot reviewed the information, and I also reviewed the letter, so I am familiar with it. I am a principal at O'Reilly Talbot Oaken, OTO, with 20 years experience working in these sort of environments, both environmental and geotech engineering. So I'm going to read this letter. Jay, I wasn't sure if you were going to share your screen to put it up there or not, but I will continue on. So this letter is dated September 1st, 2020. It is to Mr. Dan Eastman at 40 Halley Lane, Somers, Connecticut, and it's regarding the radon and uranium in well water issue at 40 Halley Lane residence in Somers. Dear Mr. Eastman, per your request, O'Reilly Talbot and Oaken Associates, OTO, has reviewed 4 July 19, 2020 letters from the Town of Somers Department of Environmental Health to the residents at 39 Long Hill Drive, 47 Long Hill Drive, 24 Amy Lane, and 175 Mountain Road. Those residences are located between 500 and greater than 1,200 feet from your residence. The closest of the properties, the 175 Mountain Road residence, is located approximately 500 feet from the nearest location of rock removal on your property. The letter documents the detection of uranium and radon in water from the potable supply wells at those properties. Per your request, this letter provides our comments on the significance of the detections and if groundwater quality will be further degraded by the ongoing removal of bedrock at the rear of your residence. In general terms, the question has been raised whether vibrations from bedrock removal at your residence could increase the concentrations of uranium and radon in potable water in these nearby wells. Section header, presence of uranium and radon in well water samples. The Town of Somers letters are correct in that the concentration of uranium is greater than the U.S. EPA maximum contaminant level, abbreviated MCL, and the radon concentration is greater than the U.S. EPA proposed MCL. We note that uranium was reportedly below the MCL standard at the 175 Mountain Road residence, and the radon level in well water at that property was within the range of the concentrations at the 4 sites. Specifically, the radon concentration of 8,840 picocuries per liter was the second lowest of the 4 data points. The state of Connecticut has not adopted uranium or radon standards for potable water supplies. Therefore, the U.S. EPA MCLs and proposed MCLs are applicable. We would like to note that while the concentration of uranium is above these standards, the radon concentration may be more significant from a health perspective. In addition, we'd like to note that the Town of Somers letter recommendation to use bottled water may not be protective of all potential exposure pathways. A potential exposure to radon may occur when it off-gases during other common activities, such as showering or hand washing. Radon gas can impact air quality during these activities and can be inhaled into the body through the lungs. Thus, the simple use of bottled water for drinking water is not necessarily protective of all the potential exposures. We would like to note that both uranium and radon are naturally occurring as a result of uranium in bedrock in the Somers area. Uranium is slightly soluble in water and thus can be present in a drinking water supply well in both its soluble form or as a result of sediment in the well. The vast majority of naturally occurring uranium is U-238, a non-radioactive isotope. However, radon is a gas that is soluble in water that results from the natural degradation of the U-235 isotope in uranium that is present at very low but still significant concentrations in the native bedrock. Thus, it is not unusual to see both uranium and radon in groundwater in the Somers area. Header, effects of blasting operations on groundwater quality. This discussion considers whether the rock removal operations at the Eastman property has or could increase the concentration of uranium and radon in water from the nearby supply wells, either by increasing the amount of dissolved uranium or the breakdown of U-235 to radon gas. This could potentially occur if the vibrations are sufficient to break the rock mass, to increase the surface area available to uranium to dissolve into groundwater, and or for radon gas to migrate through the new fissures into the well. For the reasons discussed below, little or no vibrations are likely to migrate to the depth of the water-bearing zones in the nearby wells, and any vibrations which might occur are unlikely to fracture the bedrock. When considering potential impacts to nearby wells, it is important to consider that any water supply wells in the area are likely 200 feet or more deep, and most of the water-bearing zones for the supply wells is likely present at these depths. We understand that you previously removed bedrock from your residential property via both blasting and using a hole ram. It is our opinion that neither of these activities created vibrations which could significantly impact groundwater quality in the supply wells for nearby properties for the following reasons. First, the shallow rock is relatively soft and highly jointed, which allows the rock to be broken into smaller particles with low blast energy. Also, there is a large open face which allows the blast energy to preferentially dissipate upward and not into the ground. Given the depth of the water-bearing zones in the nearby wells, it is unlikely that vibrations from the past activities adversely impacted water quality. You have asked us to comment on potential impacts from future activities. We understand that you plan on removing rock in the future by hydraulic fracturing or splitting. The process would involve the drilling of holes to the depth of approximately 4 feet and then fracturing the rock using external hydraulic source. These operations would result in only minimal vibrations during drilling. As discussed above, vibrations which might occur would migrate upward into the open space of the ground surface and not downward into the rock. Therefore, the proposed drilling and hydraulic fracturing operations should not adversely impact the concentration levels of either uranium or radon in the nearby water supply wells. We appreciate the opportunity to provide services for this project, and if you have any questions, please do not hesitate to contact us, and it is signed by James Oaken, who the founder of the company and a toxicologist background, Michael Talbot, the principal here and founder, and myself, Ashley Sullivan, principal. And if there's any questions, I know that was a lot to take in.
Questions?
I think we should just continue with
We
your...
just don't think that well testing is indicated. It's not blasting, no impact off-site, no vibrations off-site, couple 100 feet, 300 feet or more from top of the water table, just not indicated. So let me then go back to 009 and 011, the two special use permits that Jay touched on, the access issue. And as I go there, the only other comment I have to make about the rezoning is that it is consistent with your plan of conservation and development because the two zones are still in the same land use category. And as I said, that zoning amendment was recommended for approval by the Planning Commission unanimously. Let me go back to the access issue because you're going to have to discuss that and decide it. There are only two ways into the site. One of them is up Halley Lane, which is a residential street with several homes on it, and then up a narrow and difficult driveway. If you were to apply, and there's reasons why you shouldn't in this case, the 100-foot setback, you can't do it from Halley Lane because Halley Lane frontage is 175 feet. So you can't get 100 feet on each side of an access road and still come anywhere through the frontage of the Eastman house lot, regardless. And if access was on Halley Lane, you would have to use much smaller trucks and probably have twice as many trips, or maybe 2.5 times as many trips, or maybe even 3 times as many trips. As it is now, the applicant will commit to a condition on the approval of 011 that the 2,500 cubic yards of material that has to be brought in to finish the lawn can be done in 30 working days. That's it. Just 30 days of trucks coming in and going out during the hours that are provided for in your regulations. There's been some talk about shortening those hours up. If you do, it's going to take more days. But if you follow the hours mandated in your regulations, we can guarantee that that material can be brought in fact, less than 30 days, but safely 30 working days. I'll go over the whole timeline after I get done talking about the access issue, so you can take some notes, because it's very important, because what these three applications do, the special use permit 009, coupled with the lot line adjustment and the rezoning, coupled with 011, the special use permit to bring in the finished material, will end this controversy once and for all. And as Jay said, it'll be done by the end of the year. We think this can be completed in 120 calendar days and a lot fewer working days than that, which I'll spell out when I get done talking about the access issue. So you can't come in on Halley Lane and meet the 100-foot setback requirements anyway. And you can't come in from Mountain Road and meet the 100-foot setbacks requirements if they fully apply, and if you didn't have the discretion to decide otherwise. But you do. You do. In your regulations, you have broad discretion to decide where the access may be under the criteria in your regulations. So let me walk you through that fairly quickly. The 100-foot setback from the side and rear property lines for access and egress is required to be shown on the plans, and it's intended to protect the buffers that are required by Section 214-70C10 of your regulations, to be very technical. The 100-foot buffer protection is on the rear property and the side property lines of a earth excavation site. And it's a no disturbance area. It's an area where your regulations say, we don't want you cutting trees, you don't want you putting stuff down, unless you get permission of the abutting neighbors, which actually we have in a couple of small areas on the site, as you know, from the first part of the hearing. We have permission to go within 100 feet. That's fine, you can go there. But other than that, you're supposed to stay 100 feet back as a buffer. The buffer does not apply on the frontage, and it can't, logically, because you have to have a driveway go through the frontage. So the 100-foot buffer is questionable as to whether it applies to the access drive at all. The buffer provisions prohibits earth removal or filling 100 feet from the property line. The prohibited activities include, but are not limited to, quote, excavation, removal, stockpiling, clearing. It's noteworthy that the listed activities, while not exhaustive, all address activities that would disturb an existing landscape. There's nothing in your regulations to expressly prohibit access on an existing easement with an existing improved travelway that has been continuously used for years for truck access. Indeed, as the Clarks have said, this has been going on for 3 years. As those 5 Google photographs admitted to the record without our objection show, the activity does date back for 3 years. This is a long-term access use for bringing in equipment and doing operations 42. The access proposed by the applicant is existing, has been there since before the applicant purchased the property 11 years ago. The use of the access does not create any new disturbance of the landscape, and as such, a 100-foot setback does not apply to the proposed access in this application. But now I want to turn to a key provision of your regulations that I missed the first time I went through them months ago. And I went back through it and I found them and I said, but this is really important. This commission has in its regulations recognized that there will be circumstances where they have to pick one access over another access. They have to decide which is better, coming up Halley Lane or coming off of Mountain Road. So here's this provision, and I'll just read it to you. It's short. It's at 2014-70C10B. I really dislike having to read sections, numbers, but all right, here's it gives this commission, your commission, you, complete discretion in approving the access. Quote, notwithstanding the foregoing provisions, you know what that means. Forget about what the regulations say for a minute. Just stop. The commission may allow any buffer area to be crossed by a driveway or other access way not to exceed 28 feet in width and as close to 90 degrees through the buffer area as possible. And the reason for that is, which is what this driveway is, it cuts straight through so it's the shortest length rather than angling all up through a buffer. If such access is necessary to allow the conduct of the proposed activity, or if it would be more reasonable and prudent than any alternative access, the length, cost, location, and other characteristics of any alternative access may be considered by the Commission in determining whether such access would be more reasonable or prudent. That's into that section of the regulations. The 100-foot setback requirement does not apply in this case because the access way is existing, does not disturb an existing landscape, and the Commission has the authority to allow an access road 28 feet wide or less through the buffer or setback area. The Commission, in our judgment, should find that the access from Halley Way up the driveway past the residence at 40 Halley Lane is less reasonable and less prudent given the 175-foot frontage there and could not comply with the 100-foot setback regardless. and should consider the capacity of Halley Lane as a residential street with several homes on it, and the driveway requiring 2 or 3 times as many truck trips because of its narrow width. So, in summary, Mountain Road is the best access. You do have the discretion to approve it as an alternative to Halley Lane and as the most feasible and prudent for the property. I think, Jay, you said that you have that checklist too, but you pretty much summarized for 011 the 2,500 cubic yards and the relocation of the material from 40 Halley Lane, the 009 application. Is there anything further on that checklist that you need to touch on? I think not. You're on mute, Jay. Nothing more on that checklist?
Again, for the record, Jay Ursary, J.R. Russo. No, I think I've touched on most of it as I've gone through and given you an overview of the applications. Again, we believe we meet all the requirements within your regulations, and we don't think there's any reason that you would deny it based on something that we've omitted. We think we have everything covered there, and hopefully we've given you the comfort level that you need to make the decision that we're looking for. The only thing, Dwight, that I think I would add with regard to the access is that obviously the commission has the authority to vary the access and not consider the 100-foot buffer, and it's written right in their regulation. And you talked a little bit about coming in on Halley Lane and so forth, where you're going to be going for more residences and a narrow driveway and more trucks. But the other thing that, and I don't know how many people have actually driven up Halley Lane and come in on off a mountain onto Amy Lane, and one of the things that I noticed the first time that I came out of the site was when you come off of Halley onto Amy and you get to Mountain Road and you look, the sight line is not very good. When you look to the left, there's a little hill there. It's very difficult to see, and certainly you're going by many more houses in that direction with truck traffic, and the sight line, quite frankly, isn't that good, and I think it's probably not the best way for construction vehicles to be traveling in and out versus going up mountain, coming out the existing gravel access road where we have good sight line, we have an existing road, and we only have 2 homes that we're going to go by. I think it's a no-brainer in terms of the way to go and access this site. So I just wanted to add that.
All right. Well, let me wrap up here then, because we're essentially done with. And I know there'll be comments from the public and questions that need to be asked and answered, and we're ready to do that. But let me just finish with 2 things. Number one is the reason why we're here, and we go back to the town attorney's opinion letter in February, in which he said that Amy Eastman had to come in and get a permit for this activity. We can continue to argue about that in court for a long time, I think. But you know what? She's done everything that this commission wanted her to do. She's come to you with a special use permit for this work on her site to finish up what was started on 42, to exceed to all of your requirements, and on top of that, although we would much prefer to do blasting because it would be faster and cheaper and better and would have no impact on the neighbors, we know that. We've given up on it. We're not doing any blasting. And the jackhammering bothered people. It's faster, it's cheaper. We're not doing that. She's done everything that the town has asked her to do. It pains me when people use expressions like thumbing, as you heard at the beginning of the hearing. It was said that she was thumbing her nose at the town. She hasn't done that. She's turned and met every one of your requests. And this, as Jay says, this application, we've worked so hard to make sure that we've touched every single detail. We spent an enormous amount of time and effort and money to prepare these applications, and we do believe they fully comply. And if you approve them, we'll be done with this once and for all. By the end of this calendar year, we'll be done with this to everybody's benefit. Even the complaining neighbors should, in our judgment, be pleased with the fact that this has got an endpoint on it with the approval of 009, the special use permit for 40 Halley Lane, 010, the rezoning which allows us to finish that up, and 011, which enables Amy Eastman to bring in the fill material to finish the lawn. Now here's the time that can be done in. You might want to write these numbers down because there's an interplay on them. The drilling and hydraulic splitting, we estimate will take 75 work days. If we could blast, we'd be done in 3 weeks. All right? Don't want blasting? Not asking for blasting. We're going to take 75 working days, but you can't hear it. Ask the town attorney, ask the zoning enforcement officer. They heard it. They were there. They couldn't hear it off-site. So it'll take 75 days, working days. While that 75 days is running, the bringing in of the material and the moving of the excess rock from the residential lot over to what was part of 42, which is now 40, and will be rezoned to A1, is 60 days. That's 75 days, and the 60 days overlap. And of that 60 days for 011, and what I'm telling you is 009, you can condition 009 on completion in 75 days from the start of the work, 75 working days. You can condition 011 on 60 days. And of that 60 days, which overlaps with the 75, because they can be breaking up rock over here on 40 while they're bringing in this 2,500 cubic yards and moving some of the excess rock over, 30 working days will be devoted to moving the material in out of that 60 days. And we can commit to that, and the clerks who have the biggest concern will know that in 30 working days, those trucks coming in with the material will be done. And so with the overlap of 75 days to break up the rock on the residential lot, with the 60 days of bringing in the material and regrading, we believe that the work can be completed from its start, whenever that is, which would be shortly after the approvals are granted, in 4 calendar months: September, October, November, December. By early January, this will be done. And if we don't do this, we don't know how long that other process will take. But it's not desirable for anybody, not for the Eastmans, not for the town, not for the neighbors. In fact, the best thing we could do is get these approved now under your regulations, get this done, and move on. So thank you for your attention. We're available here to answer questions and try to respond to additional needs for information and explanation.
So I guess with that, we're going to open it up to the public. And I know there's not a lot of people in here, but they get a lot of feedback on this microphone from noise because we're Zooming and there's several ports of sound. 2 things. I'm going to have you sign in, name and address, and please try not to touch the microphone, or we'll have to, if you feel like you want to wipe it down before you speak, that's fine.
I'll turn it on.
And then we're going to take all the comments, and then the applicant can respond at the end. So we'll move that way. Yeah, if you know you're gonna speak, you can come up and sign in now, and that way. You can go ahead and start if you like.
Sure, thank
No
you.
sense of holding, you know.
Can you hear me okay if I keep my mask on?
We're actually concerned about the people online. Can you hear? Go ahead.
Okay, good evening. My name is Dory Famigletti. Can I be heard?
Can you hear the speaker? Give me a thumbs up if you can hear this woman speaking.
Okay, should I keep talking so I can make sure they can hear me? Okay, this is Dory Famigletti from Kahan, Kerensky, and Capicella. Thank you. As you may recall, I represent Tom and Vicki Clark, the property owners at 175 Mountain Road. And I have a few concerns. Am I okay?
What was that?
That was me not realizing I was unmuted.
Okay, so you can stay unmuted as long as you're going to be quiet.
Thank you. I have a few concerns to still address on behalf of my clients with regards to pending applications, and I'm going to break it down into a couple of different categories, please. And the first one I'm going to speak to is the access drive that we heard a lot of discussion about already tonight. And respectfully, I disagree that there's nothing in your regulations that would prevent the use of this existing access drive that's been used for 3 years. And I'll remind you, for the 3 years that it's been used for these operations, arguably it's been unregulated and unpermitted. And that's the reason that there's the pending litigation between the applicant and the town as to whether or not a permit was ever required. My client is a direct abutter of that access drive, and they continue to have concerns that the use of that drive is not permitted under your regulations. Section 214-69E of your zoning regulations requires that all access must be at least 100 feet from side and rear property lines. This restriction applies to all truck access for all activities associated with the earth removal operations. That could be trucks bringing equipment on site needed for the excavation or the fracking operations. It could be trucks on the site coming to the site to move the rock around on the site once it's extracted, and it could be the trucks that are bringing in the soil that Attorney Merriam had referred to. In response to our claim and our concern regarding this section of your regulations and what we think is prohibition in your regulations on allowing use of this access drive, counsel for the applicant directs this commission to section 214-70C-10B of your regulations. He read it into the record, and basically that section of the regulations gives this commission discretion to modify the 100-foot buffer required in both 69E as well as 70C-10A and permit an access drive in that buffer if you find it necessary to allow the conduct, or if it would be more reasonable and prudent to any alternative access. In response to that argument, I would say that section 70C-10B is an invalid and illegal regulation that operates to allow the commission, this commission, the zoning commission, to grant de facto variances, which is a power that is exclusively reserved to your zoning board of appeals. Case law is replete with court rulings that the ZBA is the only municipal agency that can vary the application of the zoning regulations. In the widely cited 2013 decision of McKenzie versus the Monroe Planning and Zoning Commission, It sets out the consistent holding of the court that a regulation purporting to allow a zoning commission to waive its own requirements is invalid. In McKenzie, the regulation at issue there set forth certain required setbacks and landscape requirements. But those regulations also contained a provision that allowed the commission to vary or modify those requirements if the commission found that the variation would provide for a more appropriate use of the land. In its review of that regulation and similar regulations, the courts have consistently held that there is nothing in the general statute that allows a commission, a zoning commission, to adopt regulations empowering themselves to vary the application of their regulations on a case-by-case basis. We believe that the authority of this commission to modify the 100-foot buffer as provided in 70C-10B is exactly the type of regulation that the McKenzie court struck down as invalid, and you cannot and should not rely on that to allow the applicant to use this off-site drive to access the property for earth removal operations. The use of this off-site drive violates the express terms of Section 21469E, and it's improper for you to vary those. Now, the recourse and the remedy for the applicant, of course, is to seek a variance from the ZBA, not from this commission. If the applicant believes that any access off of Haley Lane is not feasible, then they have the recourse to seek a variance from the ZBA. But this commission itself cannot vary its own regulations despite the section of the regulations that purports to allow it to do so. The next topic that my clients have concerns with has to do with water quality impacts. In response to a number of comments at the last hearing, as well as an email I sent to Attorney Miriam and this commission last Friday, they have now prepared and submitted to us this evening a report by OTO regarding those water quality impacts. Our concern and a number of other residents' concerns remains that the fracking or hydraulic drilling could be reasonably likely to have an impact on the groundwater supply. Now, we did hear and we listened to the expert testimony on this tonight via that letter, and I can tell you that neither my clients nor I have expertise in this area, so we are not in a position to refute that. However, I would encourage you to consult with your town sanitarian and or your town engineer simply to verify the letter, get their comments and thoughts on that letter. I'm not saying that letter is incorrect, and I'm not challenging those conclusions, but I am not qualified to do so. However, I think someone with experience, such as your engineer or your sanitarian, might be able to be in a better position to do so. And your regulations charge you with a review of groundwater issues. Section 21470C1 say that you cannot issue a special permit unless you find that the activity shall not create any condition which would impair the use of neighboring property or create a nuisance. And Section 21470C2 says that you shall not issue a special permit unless you find that the activity shall not have an adverse effect on groundwater. Again, we are not challenging the conclusions in the OTO report. We're just asking you to take the time, as your regulations require, to make sure that you're comfortable and satisfied before you issue any special permit that there, in fact, will be no groundwater concerns exacerbated or created in connection with these activities. The third general comment and concern that my clients continue to have has to do with general nuisance concerns. I have to pull this down.
That's okay. We're
Thank you. I will wipe the mic before I'm done. I'm just having trouble breathing and my glasses are fogging up.
Mine too.
Thank you. You heard from my clients and others that the noise associated with the earth removal operations that have been conducted on the applicant's property since 2018 is severely impacting their use and enjoyment of their properties. And blasting, respectfully, is not the only noise that's a nuisance. The trucks themselves have significant noise associated with them. And you, as a commission, we hope have now seen for yourselves the extent of the rock excavation and site disturbances that have been ongoing for the past 3 years. You had an opportunity to view the site, you saw the amount of landscape that was disturbed, and you saw the huge rock boulder walls that have been created around the perimeter of the site. Can you imagine the noise generated by breaking up and moving those rocks? Trucks coming and going from the site, backing up on the site, pushing those giant boulders around on the site, all generate excessive noise that causes significant nuisance and does, we submit, require action and need to be addressed by this commission. Your regulations are there to safeguard against this exact type of nuisance activity. Let's not forget, the applicant does not have an absolute right to conduct this activity. It is a specially permitted right. And therefore you have to look at it and look at the surrounding areas and look at the nature of the activity and determine whether conditions are necessary so that it will not have an impact on neighboring property owners. And you have the authority to do that. Although Section 214.71D does set forth hours of operation for earth removal activities, respectfully, my clients don't feel these go far enough to protect them from the nuisance they've been living with for 3 years now, and they urge you to consider more restrictive hours of operation. They would like to offer Monday through Friday, 8 a.m. to 4 p.m., and no weekends. Now, mind you, remember this activity has been going on for 3 years, unpermitted and unregulated, hence all of the applications and the pending litigation you have. They've been living with this noise for a lot longer than those hours. So, comments made by the applicant's attorney in his August 24th memo trying to somehow diminish those concerns by saying that, oh, your kids are up for school before activity was happening, and oh, people only cook out at night after the activity stops, and no one's using a fire pit in the summer. Those attempts to minimize the disturbance and disruption that this noise has caused to my client really are unfounded. These activities have been going on 7 days a week for much longer hours than your regulations would have allowed, and that's because they have been unregulated to date. Now, my client understands that if you further restrict the hours of operation, that would result in a corresponding extension of the overall duration of the permit, but they do believe that the tighter controls on the hours of operation would be worth it if they have to live with this continued operation for a period of time. And shortening by an hour or two a day and eliminating a couple hours that's only allowed anyway on Saturdays really wouldn't have to significantly extend the overall duration by more so than maybe 2 weeks. Sections 214.70C1 and 12 allow you to require proper measures to be implemented to minimize the nuisance of noise both on and off the premises, including any nuisance created by trucks hauling or delivering materials. Section 214-102E also requires this commission to consider the impact of the proposed special permit activity on neighboring properties, the potential creation of a nuisance, and the compatibility of the proposed special use with the nearby properties. And finally, Section 214-102F authorizes you to place whatever conditions you deem necessary to assure that the rights and convenience of local residences will be protected. Under these regulations, I believe you have the authority to restrict the hours of operation in a manner necessary and adequate to protect neighbors' concerns with regard to the noise. And the final category I'm going to briefly touch upon has to do with the zone change request that's before you as well. I know it was referenced in Attorney Miriam's comments that the Planning Commission unanimously recommended approval of the special use permits as well as the rezoning. I think that's a bit of an overstatement. When I looked at, and I wasn't at that meeting, but when I reviewed the minutes of that meeting, I will state that on the zone change, it was noted by one commission member that this could be a form of spot zoning. And in the motion that was made for a positive recommendation, a comment was to be included that the commission, zoning commission, with a comment that this could be looked at as spot zoning. So that was an indication that you should really carefully consider rezone. And on the zoning referral for special use permit number 2, which is application 011, although they did issue a favorable recommendation, it was with the specific condition that the zone change occurs. Obviously, if the zone change doesn't occur, you're not in a position to grant that second special permit request. So I just wanted to clarify that with regard to the zone change. Finally, on the zone change, in order to grant the zone change, you must review the request and make a finding that it's consistent with your plan of conservation and development. And I have reviewed your 2015 plan that's online, and I just have to offer 2 items for your consideration when you evaluate this tonight. First, on page 14 of the plan, it is stated that protecting water quality is Summers' highest natural resource protection priority. Summers' surface and groundwater resources provide potable water, contribute to biological diversity, and add to the overall quality of life. My clients want you to look carefully at that groundwater. Again, we're not disputing the OTO report, but I would ask you to look at it critically and have the town staff that's at your disposal, such as your sanitarian and engineer, review it and just offer their comment before you make a decision. We suggest that perhaps by not rezoning these roughly 5 acres from A to A1, and thereby not allowing the use of that land for removal of earth products, which is again only allowed in the A1 zone, you may be protecting water quality in a manner that is consistent with the very important stated goal of your plan. And secondly, on page 26 of your plan, it is noted that the scenic character of the town plays a significant role in the overall character of Summers, and efforts should continue to be devoted to protecting the scenic features. And scenic features specifically include hilltops and hillsides. Well, you have a mountain hilltop here, a mountain exposure that you used to have before it was taken down, but there is still some existing mountain hilltop here that has not yet been disturbed. And it's a significant scenic attribute of the town. Similar to what I had just stated, my client suggests your consideration that if you don't rezone these 5.5 acres to A1, and therefore do not allow a potential use for earth excavation, you would be protecting the hilltops and mountain ridges that are considered valuable scenic features to the town. Now, I want to, in closing, just remind you that for almost 3 years now, my client's use and enjoyment of their property has been significantly impaired by the applicant's earth removal operations. I will reiterate, my clients are not unreasonable people, and they accept that one might be expected to endure this type of brief annoyance for a short term when homeowners nearby are doing construction projects. But this has been going on for 3 years. This is not a short-term project, despite what Attorney Merriam states, that this would be a short-term completion of these activities. Let's not lose sight of the fact that although they may only take another 4 months to complete, they've been going on for 3 years and significantly impacting my client's use and enjoyment of their property since then. Enough is enough, and now is the time to do something about it. You have the applicant before you with an actual application now, and you have the opportunity to control and regulate these activities pursuant to your regulations. If you are going to issue this permit, please take this opportunity to do what's necessary to protect the neighbors who have been enduring this for so long. And then finally, just on some of the comments that were made earlier, we have no questions, or I have no questions remaining regarding Jay Ursery's explanation with the depth to water table and his bonding. I would, however, remind you that under section 214-73, in addition to the bonding, there's an inspection fee that is required in connection with these types of activities. I think that inspection fee is important important to not forget, because if you are going to issue this permit, it's going to be really important to have a staff member dedicated to monitoring compliance. I don't know exactly how you're going to do that, but perhaps if you have the applicant submit a work schedule ahead of time so staff knows when people will be working, so they can track the actual working days and track when actually work commences and when it's got to be done by, and track how many days are being used on whatever access drive is ultimately used to get to this site. I think it's important to make sure you add that in as well. So we thank you. I know you've spent a lot of time over the last couple months, but also over the last couple years grappling with this issue, just like my clients have. Please take advantage of the opportunity with the applicant in front of you now to put the necessary controls on it if you're inclined to approve this application. Thank you.
Thank you.
I'm going to take this off,
Yeah.
if you don't mind, because I'm just going to fog up and I'm not going to be able to read. Can anyone hear me okay? Okay. All right, good evening. We are Vicki and Tom Clark from 175 Mountain Road. Unfortunately, we've had to stand before you to speak publicly about what we have endured these last several years. This is not something that we relish to do. In fact, Vicki and I absolutely hate to be up here. However, it is necessary to protect our greatest asset, which is our home, and our family's quality of life. There are two concepts that we would urge you to strongly consider. The first is reasonableness and quiet enjoyment. All homeowners have a right to quiet enjoyment of their property. That essentially means that property owners should be able to use his or her property without interference from others. When courts decide if a neighbor's actions violate a property owner's right to quiet enjoyment, typically the duration of the neighbor's actions, the reasons for the actions, and the impact or burden on the adjoining property owners are considered. Ultimately, however, the mere violation of town zoning regulations is powerful evidence of a use being unreasonable. Vicki and I have never asserted that we wish to control anyone else's use of their property. Rather, we are advocates of folks using their property the way they see fit. However, people are expected to use their property reasonably, and I'm going to stress again, reasonably, without injuring the rights of adjoining owners. All of us who own property have certain mutual rights, duties, and obligations. The actions taken by the Eastmans have substantially deprived the abutting neighbors of our reasonable and quiet enjoyment of our properties. There is no debating this. If the Eastmans had thoroughly thought this through, abided by the regulations, acted in a reasonable way, and perhaps even reached out to the multitude of adjoining lot owners, we most likely would not be in the situation that we are here tonight. There is no doubt that our quiet enjoyment of our land has been significantly affected, interrupted, and disturbed by the Eastmans. Actions speak louder than words is the second concept we'd like you to consider. Unfortunately, if you look back at the Eastmans' past actions, you will see a pattern. The pattern from the beginning is complete disregard for summer zoning regulations. Whether they initially intended to circumvent the regulation or just didn't take the time to reach out to the building and land use departments to determine what they could do and couldn't do is debatable. The result has been long-term adverse effect that these actions have had on the quality of life of all the adjoining neighbors, as well as residents as far away from as Woods Road and Sky Ridge, as noise complaints have been documented by the resident trooper's office in both those areas. Because of his actions and because of the constant complaining by many neighbors, the Eastmans had to retain a bevy of attorneys to backtrack on what he did illegally. They tried to find loopholes and skew intended zoning regulation language in order to meet his needs. He has complained to me that this has been costly for him, and no doubt it has. But the blame falls squarely on their shoulders. He has told me that he is a businessman, that he evaluates risk with every decision. Evidently, he must have felt the risk not to comply with zoning regulations was minimal. Sadly, he might have been correct. He has been able to create a quarry and remove thousands of tons of ledge in an A zone, which strictly prohibits the type of excavation activity. Even in an A1 zone, a project of this size would have required a permit, accurate site plan submission. The town, unfortunately, also has some culpability in the situation. Early on, it was apprised of the work that was going on, and we were told that there were permits. Upon further investigation, it was revealed that there were not any permits. It is a puzzlement that work continued without permits. It wasn't until the last year or so that a stance was taken by the town after an overwhelming amount of complaints. The reason people are so passionate about this is our biggest assets are our homes. One of the attorneys claimed in a prior version of this application that the improvements the Eastmans are making could enhance the value of the surrounding properties. However, you can clearly see by the properties that have been difficult to sell and those that have sold for a lesser value, this in fact is beginning to impact value. This project is creating what is known as detrimental conditions, which can diminish values. Time will tell if it will be temporary or permanent. I would like to address and clarify statements that Dwight Merriam alleged in his memorandum dated August 24, 2020. I can assure you, Vicki and I never, nor would we ever, trespass on anyone's property, including the Eastmans. First, the claim that Mountain Road access is the best and most appropriate access. When we moved into our house in 2009, where the access road is now located, which is where the commission members walked up on the site visit, there was dense forest, much like the rest of the woods on a neighboring side, which is the Robiati side, as well as our side. The access road was carved out over approximately 1 year's worth of work, give or take. Trees were removed. It was jackhammered within 80 feet of our house for quite some time. And we also have text from the contractor that was performing the work telling us that he would be completed soon. Fill and material for the road was trucked in. We had made numerous complaints to the town several years ago regarding this, and it is documented in prior public hearings over the last few years. We reported pictures falling off the walls of our house due to the close proximity of the jackhammering. To say that the road existed is an inaccurate statement. The Eastmans put the road in, and all these years later, we now find that there is a variance needed to be able to utilize that road. We have been going back and forth with the town for several years because there has been significant commercial truck traffic going up and down that road for years. Dump trucks, heavy equipment, fuel trucks, and excavators, blasting and drilling equipment. Second, regarding the ingress and egress, Dwight alleges that using Eastman's driveway at 40 Holly Lane would not be feasible, although in earlier proposals their driveway was always listed as an option. In fact, before the last meetings, I stood outside speaking to Dan. I asked him the very question of why he couldn't utilize his driveway as an ingress and egress for truck traffic, as he proposes. His response was that he could not fit the trucks through the stone pillars in front of his driveway. I then suggested that he could remove the stone pillars temporarily, and he indicated that he would not. I can only come to the conclusion that with all the money he has told me he has spent, he most likely did not want the trucks entering his driveway, as it would disrupt his quiet enjoyment of his property. The fact that he did not want to endure that and would relegate that happening for other neighbors by utilizing the access road speaks volumes of the unwanted noise and disruption that he himself does not want. I did recently see that one of the neighbors has a photograph of a large floater barn shed on a flatbed, which is posted, quote, wide load, going up his driveway about a year ago. So it would appear a wide load could go up his driveway. In this new proposal, it is now stated that the Eastman's driveway is not a viable ingress and egress for a variety of situations. And we now know that the access road is also in violation of regulations. The 100-foot setback requirement has not been met on either side of the neighbors. They are asking for a variance, which by law requires a neighbor's approval. Does this mean that there is no conforming ingress and egress to the entire project? Regarding Dwight's statement of a negotiated settlement with us, approximately 45 minutes prior to the August 3rd meeting, our attorney contacted us and indicated there was a proposal on the table that Dwight had presented to her. When she arrived approximately a half hour prior to the meeting, she briefed Vicki and I on the proposal. Approximately 15 minutes before the meeting began, we met with Dwight, and we were provided with additional facts about their proposal. We were told several times by Dwight that if a decision was not made that night, right before the meeting, that all bets were off the table. Meanwhile, the commencement time of the meeting was being delayed, and in fact, Jen Royd had to come outside to ask us at least once, maybe twice, to enter the meeting room so that the meeting could begin. In essence, we were being forced to make a decision at that juncture. In a reasonable negotiation, both parties are provided time to weigh decisions. It was important to us not only to understand how this proposal would affect us, but also our neighbors. There was no reason that Dwight could not have provided a proposal several days earlier and allowed Vicki and I the courtesy to digest the proposal. Whether it was done as a legal strategy or not, I'm unsure. However, what I was sure of We were not going to make a split-second decision under duress. There is an assertion that the trucks and construction would not wake the kids. I will share with you that our oldest daughter, who's now a junior in college, used to wake to this every day when she was in high school. In fact, there were more days than I can count that they were late for school because flatbeds and dump trucks would block our driveway as far back as 2015 and 2016. The work would go on from 6 a.m. sometimes until 9 p.m., weekdays and weekends. We have spoken about this in the past. We would concur with the chairman of the planning's assessment that this change requested is a spot zoning action. We trust the commission will make a decision that it is again in the best interest of the community now and in the future. However, as a reminder, this is the same zoning code A the town residents spoke about to keep intact with regard to all the work done with planimetrics and the revision of the zoning regulations. Seemingly a decision has already been made about the zoning classification. We have been told the commission members have had the ability to walk 40 and 42 Halley Lane and observe the work site. It is significant that work had been taking place unpermitted with no oversight. That substantiates all the noise complaints, all the commercial truck traffic, the jackhammering, drilling, and the blasting, everything that all the neighbors have been complaining about over the years. You can look back at the topographical maps and see what the original elevations were. Recently, at least a half a dozen or so neighbors, including Vicki and I, have had our wells tested. The town sanitarian, Steve Jacobs, took independent samples from all the houses and submitted them to the state lab. We were told our drinking water is not advisable due to the test result of the state lab. The results show elevations in a variety of categories, but most notably uranium and radon. According to DEEP guidelines, there should have been pre-blast and post-blast samples allowing officials to legitimately analyze the effects. However, this was not done. To the commission members, we know and understand you are in an unenviable situation. We also understand that this is a volunteer position and that most of you have not encountered a situation like this before. However, as you are well aware, among the statutory responsibilities of the Zoning Commission is the duty to enact and administer the town's zoning regulations, which have been established to preserve the quality of life and property values in Somers. The adjoining landowners and I have come before this commission over the past several years, and what has remained a constant has been our factual reporting of what has been occurring at 40 and 42 Halley Lane and the access road. If you go back and look at our public testimony, there has been no deviation. We haven't skewed facts in order to present a better case before you. The reason why we haven't had to do that is because we've been truthful and factual in reporting all these events. Dan has told me over and over again he's going to win this. Unfortunately to us, there are no winners. We are all losers. To the rest of us, this is not a game or sport. Please consider that the current proposal will require 125 triaxle trucks to bring approximately 2,500 yards of soil to the property. This means every truck will have a trip up and a trip down, which in fact is 250 truck trips. If they decide to bring even more in to cover the rest of what they have already cleared, guessing close to 19,000 cubic yards or more, then that would require a significant amount more of truck traffic, approximately 38 feet from our property line and 80 feet from our home. Consider what all the adjoining landowners have endured because of one individual's choices and actions. Our property values, the environmental impacts, our quality of life, and absolute loss of quiet enjoyment. Your decisions now will establish for how property rights and property values will and will not be protected in this community for many years. Thank you for the opportunity to speak before you. I appreciate it.
My name is Joseph Figler. I am at 159 Mountain Road. Again, that's Joseph Figler, 159 Mountain Road. I just want to make sure, as I was omitted from the last meeting.
It's written on the list, right? Thank you.
Yeah, just wanted to make sure.
Thank you.
So, I would like to begin by stating, once again starting off with a definition from Merriam-Webster Dictionary of precedent. something that is done or said that may serve as an example or a rule to authorize or justify a subsequent act of the same and generalized kind of verdict and has no precedent. The reason I bring that up once again is to echo what Mr. Clark had stated, is the fact that the accidents that have happened because of Mr. Eastman have set a kind of precedent as far as what's been going on for the last 3 years. We have as neighbors come to this board against the actions of Mr. Eastman due to the fact of him doing it without any permits, without any actual regulation, anyone monitoring, and unfortunately, our complaints have met with zero enforcement of cease and desist, nor any type of stopping of the actions, so to speak. Unfortunately, instead, we have gotten other things, such as Mr. Merriam effectively trying to tell everybody how it should go based on his opinion. Last time I had checked, we had an elected first selectman, Bud Noor, and we have a panel of 5 appointed in zoning commission officers who make the decisions based on the facts and evidence presented to them accordingly. The encouraging of, and the, for lack of better terminology, gaslighting of the circumstances in order to try to force decisions is not within the purview of what the zoning commission does. Now, the fact of the matter is that the Eastmans have been, for the last several years, continuously approaching this commission with an application, getting basically everybody in the area comes up to these meetings and then decides to withdraw the application. This has happened on numerous occasions. I'm actually slightly surprised this did not happen tonight. The fact is that they have continued to effectively, as Mr. Merriam put it, thumb their nose as far as the procedures and regulations and rules as to what the zoning commission and the zoning board has stated as far as what is actually supposed to be enforced. Unfortunately, once again, I am up here stating, and the Clarks, Ms. Grigger, and others as well, once again stating the same exact thing over and over and over and over again. The bottom line is that Mr. Merriam has stated that the soonest method for this is 120 days due to getting, if this gets approved. But again, negating the one simple fact that the fastest way for this to stop would be for the Eastmans to stop, for this to be denied, and for the Mr. Eastman to understand that he bought the property. It was him who purchased the property, however many years he did. It was him who made the decision to purchase the property on top of a mountain. It was his decision to attempt to clear off this property. No one else's. No one held the gun to his head. No one said, you have to do this. He's chosen to do this. He chose to jackhammer without permission, under the rules of a cease and desist. He chose to attempt to quick blast whatever he was able to blast. He is now choosing to once again submit this application for the hydraulic drilling that he is doing. Again, choosing. But the fact is it is a choice that he is choosing to do. As he has stated, it is his choice. It is also his choice to go off of what his lawyers state as opposed to what the town states. It is his choice to state that he basically doesn't have to listen to the town because of the fact of his lawyers tell him he can do what he wants to do. Again, this is all things that we've all heard before. I'm sure that everybody's tired of us hearing the same battles over and over and over again. But, as has been stated before, this has been going on for 3 years. 3 years, one man's desire to have a flat land on top of a mountain has disrupted how many neighbors, how many complaints, caused so many things, so much upsetting throughout the entire area for one man to do whatever he feels like doing. One other quick thing. As I stated before, I live at 159 Mountain Road, which is on the opposite side of the Robiatis, one house away from the in-question easement. I have actually I've witnessed several almost accidents because of dump trucks, flatbeds, and various other construction equipment blocking that easement, left unattended, no cones, no nothing, because the construction team that they happen to have there just decided to leave it there at the end of the thing, to go and do whatever they were doing up on the easement. As I live on that road, the site, I don't know what Mr. Russo had stated as far as the sight lines are concerned. I live on that road. I have to check 3, 4, 5 times to make sure that there's not someone coming down, just because it is just so terrible of sight lines. It is twisty, it is curvy, it is much too dangerous for any type of commercial type vehicle to be on, let alone go up an easement that they're not supposed to go in the first place. As far as the creating a nuisance, because of the work that was done while under cease and desist, and all of the continuous driving of all the trucks, as I've stated before, my wife has now developed a nice little anxiety and disorder because of all of these trucks. My wife and I last year, before the jackhammering, were down in New Jersey on our anniversary, and we were woken up because a truck happened to be coming down, nowhere near the property, but she all of a sudden woke up in a panic attack because of a truck due to Mr. Eastman having these trucks go up and down continuously. Now, as I said the last time I was speaking up here, if I do something wrong at my job, and I do it enough, I get fired. If I break the law, I get arrested, or I get fined, or I get ticketed. But there is a consequence to my action. And the problem is that, and this goes back to what I was saying about precedent, the fact of the matter is that the precedent has to this point been made that as long as someone rattles their saber long enough, they get to ignore all types of consequences for their action. As I have pointed out personally to Ms. Roy as well as several other members, the punishment for violating a cease and desist is a fine for the amount of days up to 30 days jail time. When I talked to Mr. Eastman about this, Mr. Eastman's response was not, oh, hey, it has never been enforced. So that, to me, denotes a person who understands that he is breaking laws. And why should he be rewarded for breaking laws by getting something that he is choosing to do himself approved? Now, I believe that I think I've made my point and hammered it home. So, I want to thank you for your time.
I'm Jen Greger, 24 Amy Lane. We've reported to the zoning office and commission since June 2019 all the violations that were ignored despite cease and desist. All were confirmed by Mr. Landolina to be unpermitted and not allowable. We reported to the town, ZBA, and the zoning commission the noise that was unbearable, and we could not even enjoy being outside for 3 months this year. We had to find ways to drown it out, even inside our homes. Mr. Merriam's statement says no one can hear it. That is fundamentally untrue. While it's not going to be as loud as jackhammering, it is noisy and is heard throughout the neighborhood as a continuous thumping and swirling sound, and is vibrational activity on the property. But the real noise Mr. Merriam left out is in his statement is the excavation of rock, the crushing and crashing and pushing against metal with the incessant beeping of equipment. It can be deafening at times. Satellite photos of the ongoing work since 2015 to 2019 appear to show what we have been reporting to the town, and doesn't include the work we heard from doesn't include the work we heard from this year. The zoning commission viewed the changes on site, guided by Mr. Eastman and Mr. Usry, as I observed when going to visit the Clarks last week. The changes, all unpermitted, are rather remarkable since 2017, I'm sure you'd agree. Amy Eastman is quite literally blowing up the mountaintop, which is no small feat. Imagine receiving a letter in the mail with your water results that say, "We recommend that this water is not to be used for consumption. All occupants of the household should use bottled water from an approved source." Included were fact sheets that included how the water vaporizes, which is then breathed in when showering, and further information online you can find is the leading cause of lung cancer in non-smokers with cellular changes that may cause cancer in 5 to 25 years. The only way to make it safe is to install a treatment system. Imagine as a nearby resident if you can't afford this. There are currently no resources with DEEP or Connecticut Department of Public Health to offset these potentially life-saving mitigation systems. High uranium results came back again. The fact sheets describe how drinking the water with elevated levels of uranium affects the kidneys over time. The only way to make it safe is to install a treatment system. Department of Public Health Wells Water Specialist stated to me, "This appears to, quote, warrant further discussion," end quote, referring to the man-made activity affecting the natural elements in the ground. Radon going from 6,400 last year to 16,800 this year is not a normal fluctuation. That's a 260% increase. To maintain these systems costs money. It needs water testing and servicing every year to make sure the system is working properly. Given the health risks and consequences of ingesting and inhaling these elements that appear to have increased with the jackhammering, long-term heavy excavation, and man-made vibrational activity, my family had no choice but to install and must now maintain 3 systems in order to have safe water. I haven't heard any studies by the applicant that conclusively state hydraulic fracturing and heavy excavation vibrations don't affect these elements in the neighbor's water. But I have had conversations with DPH that indicate heavy vibrational activity, the man-made activity, can potentially have an effect. And once again was told my results warrant further discussion on this matter. If this doesn't give pause to the zoning commission to know more while waiting for pending water results of other neighbors, then I don't know what will. I've included the properties that have sold in the last 2 years while the worst of the noise and excavation was taking place. The selling prices are significantly lower than the listed market value and could be considered as quite plausibly affected by the quarry in the neighborhood. Mr. Merriam will have you believe this is not a quarry. However, by definition, it is a place, typically a large, deep pit from which stone and other materials are or have been extracted. You've all been up to the site. Is this not exactly that? A large, deep pit where stone was and is proposed to have more extracted and pushed all around the property. The applications are asking for the same, removing stone and placing elsewhere on the property, creating a large, deep pit. 20 feet deep, I believe the application is asking to remove. By definition, it doesn't say quarry stone is trucked down the mountain, only that it was extracted. The property owner has admitted stone was extracted and put elsewhere on the property and is asking to do much more. If you find reason to issue a special use permit, please keep in mind all that we have been through, all that we will now have to go through even more, and the devil is in the details. What does 120 days really mean? 120 days over the entire year, or consecutive 120 days? That will be the end? Doubtful, as this has been going on for years and does not include the plans the property owner has told so many of us. I know that last piece is not for your determination today, but it is coming our way. Consider this. Number 1. Our windows are closed mostly November through March. That's 120 days. If the parameters of 120 days and no more are specifically that, then November through March would be special contingencies in which to set the special use permit to be most considerate to the neighbors. Number 2, the Eastmans have a front driveway that they have proposed using. There's no problem getting heavy equipment up or down by dropping it off at the bottom and driving it up or down the equipment on a paved driveway. I've witnessed this and brought a photo as an example I took from my front door. On many occasions, heavy equipment was dropped off and picked up from the bottom of the driveway located on Holly Lane. A large shed was taken up the front driveway, hooked up to the truck towing it. If this project is important for the family, as their attorney says, and the zoning commission decides to legitimize all of this unpermitted work by issuing a special use permit, why not let the family who wants... We have vibrational activity.
I must be... that microphone.
Broken cat.
Residual effect. Thank you. All right, hold on a second. Yeah. Oh, if this project is as important for their family as their attorney says, and the zoning commission decides to legitimize all of this unpermitted work by issuing a special use permit, why not let the family who wants it to be inconvenienced and experience the minor noises as their attorney states? A paved driveway is, after all, much quieter and not dusty and will be easier to navigate. The home closest to this activity is the property owner requesting the special use permit. 175 to 260 dump trucks, the 10 or 15 ton size, one way through the neighborhood, why not? No one in the neighborhood is complaining about the traffic with the current entourage of cars that head up and down each day to maintain the 40 Holly Lane household and property already. Limit it from Monday through Friday, 9 to 3. 10 trucks per day over 6 hours isn't bad. Conceivably, one truck every 30 to 45 minutes. You could have 10 to 12 trucks per day deliver soil over 30 days. The property owner could decide which days are most convenient for these deliveries, as it's his driveway. Doesn't the property owner want to be as courteous to her neighbors as possible? If you really, this is number 3, if you really believe that vibrational activity isn't affecting our water, despite the results brought forth, limit on-site work from 9 to 4 on Monday through Friday. This would allow for the added traffic not to affect the neighbors coming and going to work as much. This time frame should work out nicely with a little bit of daylight hours to still enjoy our own properties on the nice days and weekends. Remember, there are many who cannot afford mitigation, and those are the ones you should protect the most and can't be ignored. Property values can't be ignored. Quality of life and enjoyment of our properties can't be ignored. Our health and safety can't be ignored. But if you must concede, choose these compromises where the property owner gets what she wants, which is why we are here. Please keep in mind and consider the greater good. Consider the precedents you're setting for this one person and the ramifications it will have on the town. How will you ever enforce regulations, especially with those of us abutting and in the neighborhood? We will always be able to refer to this as the example. The whole town will be able to refer to this as the example. For the record, I oppose 20-009, 20-010, and 20-011. Thank you for your time and consideration, but actually I wanted to point out I have a picture that I took. It is a wide load. It's an oversized load. It was like a Cloder Farm shed that went up his driveway.
Are you giving us a copy of that?
You're going to have to leave that with us.
Yeah, I'm going to give you the whole packet, but I'm just kind of...
Yeah, I can't really see it from here. I don't see it out there.
Included is the letter that Steve Jacobs sent to me that I already quoted.
You have that?
You have that?
Mm-hmm.
Okay. Well, it's in here. And it has my water results from last year to prove that I'm speaking the truth. And then these were the fact sheets that were sent by Steve. Did you get those?
No.
So one is for radon, one is for uranium. So those were sent to me and actually my other neighbors too. And then I went ahead and I found the sales in the neighborhood for the last couple of years, their closing date, their list price, and their closing price, just so you can see the significant decrease. I also wanted to point out, hang on. In the O'Reilly, Talbot, and Oken report, while I did not ask them to review my water levels, I did find it interesting that there is no mention of the significant radon changes at 24 Amy Lane or the other two Long Hill properties. or how that could happen. Which brings us back to conversations with DPH experts who explain how fissures can be created with man-made vibrational activity and do not adhere to a 500-foot boundary. Why would DEEP and DPH advise us to test and be concerned knowing we were beyond 500 feet, as Mr. Merriam was discussing? I think at this point, I would advise, and I said this last time, that zoning speak to DPH and potentially get an independent study conducted. I think we also need time for these levels to stabilize. That can only happen with time. I also kind of noticed here that this letter was written to and for Mr. Dan Eastman, similar to the one back in November 2019. It was for Mr. Eastman, and I'd like to point out that page 4 of the report, number 5, says, "Our report was prepared for the exclusive benefit of our client. Reliance upon the report and its conclusions is not made to third parties or future property owners." So while that one, it's, to me, I don't know if that should even be used. I'm wondering about this one as well, if that's the same limitations that they are applying to this one as well. I think that's it. Thank you.
Thank you. I'm not sure if that's on.
It is on.
Gotta talk a little closer, I guess. Or louder.
I'll try to speak up.
Okay.
Sandy Olearsic, 47 Long Hill Drive. I implore the Zoning Commission to deny the applicant's rezoning application and both special use permits. In previous meetings, I have detailed the impacts to our residential water that I believe are caused by the unpermitted work that has already taken place on these properties. Regrettably, the water situation is just getting worse. In tests conducted in July 2020 by Steve Jacobs, the town sanitarian, our water hardness again increased, and our radon and water levels have more than doubled compared to prior testing in September 2019, only 10 months ago. In fact, Mr. Jacobs states that the water should not be used for consumption. I do not believe these are natural fluctuations in our radon or water hardness levels, but man-made and caused by the applicant's previous extensive evacuation, blasting, and drilling that most likely opened new fissures in the rock, impacting where the groundwater traveled and potentially releasing additional naturally occurring radon and uranium from the bedrock into the water. While the zoning issues at hand have been repackaged and restated numerous times over countless planning, commission, and Board of Appeals meetings, the nature of the work remains the same. If it looks like a duck, swims like a duck, and quacks like a duck, then it's a duck, no matter how many applications are made and amended, boundary lines redrawn, and variances and zone changes sought. If you have seen the site, which I hope the Zoning Commission members took the opportunity to do so, it's readily apparent how much has occurred and how much the applicant still has to do. We are talking about excavation that has and will continue to extensively alter the landscape and bedrock. This is evidenced by the amount of materials that have been excavated previously and that are estimated to still be excavated if these applications are approved. It's evidenced by the length of time that the work has taken already and is estimated to continue to take up to 120 additional calendar days, and by the means that has occurred: clearing, blasting, and hydraulic jackhammering. Focusing on the legalities of the permit applications, the applicant has not met the criteria for these special use permits. Instead, what applicant has accomplished is to create sharp depressions and declivities, as evidenced by the fact that she still needs to bring in thousands of cubic yards of topsoil to fill in. As stated above, the applicant has impacted the groundwater, and many neighbors' well water test results are still pending by the town sanitarian. There has been disruption to neighbors in terms of noise, and I believe a diminution in property values due to this activity, and of course, the poor water quality. Additionally, I have concerns over the precedent of allowing the willy-nilly rezoning of acreage from residential A to A1 to accomplish what otherwise would not be allowable. Due to the continued impact on well water, the disruption to the neighbors, and the failure to meet the criteria for the special use permit, I strongly urge the Commission to deny the pending applications. Thank you very much for your time.
Thank you. Is there anybody else here that would like to speak before we open it up to our virtual friends? If there's anybody online that would like to speak that hasn't spoke, they can unmute themselves, state their name and address.
Yes, this is Patricia Bannock. I'm from 104 Green Tree Lane in Summers. And I would like to support my neighbors, Tom and Vicki Clark, and the other neighbors who've spoken in opposition to the special use permit and the rezoning. And I think my interest in this is really the big picture. Green Tree Lane is quite a distance from where all of this work is going on. And the noise was evident down here for weeks and months. And for a long time, I didn't even know where it was coming from. And my position in this has to do with why the zoning regulations exist. They exist to protect all of us. And I think Tom Figler's point about precedent is a point well taken. I don't see any reason why the fact that the Eastmans have been doing unpermitted work for 3 years should be a cause to allow them to have a special use permit and rezoning now, after all of this has been going on, in violation of the zoning regulations and in violation of cease and desist orders. I don't understand what the hardship is. The house I live in and have lived in for 37 years is about 8 feet from ledge. And when I wanted to expand and renovate my kitchen, an architect gave me a plan that would have almost certainly required us to blast. And I looked at that and I said, this doesn't make sense. The property is not suitable for this. So I found another way to do it. But the Eastmans considered a hardship that they don't have, according to a previous letter that was submitted by them, a place to possibly build a barn or gazebo or create stone walls or a play area for the children. Those were things out of their letter. I don't understand the hardship. The Eastmans had property and they chose to put a swimming pool on the flat area where they could have done these other things. That's a choice they made. They bought the property. It had limitations, and now they expect the town to waive the zoning regulations and allow special use and rezoning, creating basically an ongoing nightmare for the closest neighbors. And I don't think it's right. I just don't think it's right. And I think that the zoning commission needs to follow the rules that are set. If there was some real hardship here, I could understand, but this is a choice. The Eastmans have acres of property, and they've decided they want to take off a huge chunk of it in violation of the permitting process. This doesn't make any sense to me. And the solution to finishing the project is going to create ongoing noise from the trucks. There's no way that that isn't going to be noisy. So I strongly urge you to look at the rules as written and to consider why this has been done for years, literally, with no permits, and now they're asking you to complete it, and they're suggesting they're going to complete it in a very nice way, quickly, and nobody will be bothered. Well, The fact that they've been doing it all this time is not reason to allow it to continue. It should have been shut down a long time ago. So I really urge you to look at the precedent you're creating. The zoning regulations exist to protect all of us, and I hope you'll take that into consideration. Thank you.
Thank you. Again, if there's anybody else online virtually that would like to unmute themselves and speak that hasn't spoken, please do so.
Hello, this is Ellen and Howard Smithline, 10 Halley Lane. And we, again, agree with what our neighbors are saying in regards to we do not want additional changes made to the zoning or to any type of permits. And they have already explained as to why. Thank you very much.
Next person online, feel free to unmute yourself.
Yes, this is Donald Bridge.
Donald Bridge?
Yep, Donald Bridge Jr. of 238 Root Road.
238 Root Road.
And I'm speaking in support of everyone in the town here that has already spoke against this. While I'm a distance from this, I've noticed the noise and the blasting and the jackhammering over the years. Again, quite a distance, so I can't imagine having to endure that being in the neighborhood. I have I'm concerned about the water and the aquifer. I don't know if it would affect me coming my distance, but more importantly, I'm really going to speak more about the traffic because that is, I guess, my living. The trucks in the area on Mountain Road and even Halley Lane, Amy Lane, all those areas, those roads are not made for large trucks. The gravel driveway that comes out onto Mountain Road, I've gone out on Mountain Road quite a bit in different areas. That road does not, it is not a road where you should be driving large trucks up and down and accessing a roadway where there's other traffic coming out. There's not a good sight line, as somebody has already stated. The sight line there, as well as the other roads coming out, are all not very well because the road is small, it's narrow, it's turny, it's hilly. It has quite a grade for trucks going up and down. If you're going to do this, which I would disagree with, I would definitely be restricting the time of travel to eliminate morning travel and afternoon travel so that people going out, going to work, going to things, the roadway is less traveled. There's evidence from when they delivered equipment on that road, and I've run across it myself, where they drop trucks onto the equipment onto the newly paved road, because Mountain Road has just been repaved over the recent few years, where the excavators, they drove onto the asphalt and have damaged the asphalt there. Again, showing no concern for any rules or regulations and whatnot. The road to their own driveway has plenty of space. There is no problem. I have driven trucks. I've worked in construction. I'm also currently in law enforcement, and I deal with commercial vehicles on a daily basis. So I'm well aware of the size issues and things like that. If you're going to allow trucks, and I would make sure that there was some restrictions to the size of trucks because of the hilly nature of the neighborhood coming up and down and going in and the noise for that. And on Mountain Road, that is not a place to have trucks going up and down. It needs to be limited at best. So, again, I'm in agreement with all the neighbors in the neighborhood that this should not be allowed. They've shown a disregard for the regulations, for being told what they shouldn't be doing, to cease and desist and continue to work. And I've heard the noise from a distance, so and that's all.
Hi, this is Kristen Curran. I'm at 9 Halley Lane, and I also am opposed to the rezoning and special use permits. I'm in support of my neighbors and their concerns for the noise, the water quality, and the precedence this would set in making this allowable. Thank you.
Is there anybody else online that would like to make a comment or be heard?
I have a couple here too.
We do a couple correspondence.
Yeah.
I noticed on here that Scott Soros had posted a comment. Scott, did you want to unmute yourself?
Sure, thanks, Jill. Scott Soares, 39 Albemarle Road, Longmeadow, Massachusetts. And actually, I've been attending these hearings on behalf of my aunt, Carol Folkowski, from 19 Root Road. I'll get on the comment that I typed in. I was most curious during Ms. Sullivan's presentation whether or not there was any on-the-ground analysis of or if it was all done through just the geologic maps that were done. But that question I pulled off the table at this point. But since I have the opportunity while I'm commenting, I will also echo the continued concerns that you've heard from the neighborhood that oppose the issuing of special use permits as well as the rezoning. And my aunt has continued, and I think she was able to ring in on the last call, continued to be concerned about the activity that's happening abutting her property on the back side. And I've personally witnessed some of the activity that's been done in the wood line right up to her property line, where trees in some cases have fallen across the property line, and there's been little disregard for care of the property, in addition to the disregard for the town's regulations. And I think, contrary to what was heard earlier on during tonight's presentations, it did appear to be a thumbing of the nose towards the town's regulations and a clear violation of a cease and desist that was issued by the town itself. So to sum up, again, on behalf of Carol Folkowski, opposing special use permits as well as the rezoning. Thanks for your time.
Thank you. There's a few more people that are visibly online. Is there anything you'd like to say?
Madam Chair, do you want me to offer some rebuttal at this point if I have some? I do.
I have 3.
Yeah, no, we have 3 correspondence that Jennifer's going to just go through light.
Read them into the record. Jerry Tarbox, 2 Meadowbrook Road in Summers, sent a letter basically outlining his objection to changing the zone from A to A1. He's concerned about how the changes will impact other properties and projects within the town. And then...
Just summarizing those, right?
Correct,
yeah.
Just summarizing. Then email from Jacob Basalion. Rosehaven Road. He also is objecting to the special use permit for 40 and 42 Haley and objecting to the zone change from A to A1. And then lastly, Amanda Besky, 25 Long Hill Drive. She and her husband John are opposed to the excavation, removal, and fill for application number 20-009. That's it, I believe. The other documentation, correspondence, was from Attorney Dory Famigletti, and it was a copy of several letters from Steve Jacobs to the clerks, the Olersics, Griegers and Nash regarding their well. So that was submitted, as well as satellite photos from Jen Grieger from 2015, 16, 17, 18, and 19 from Google. That's it? Yep.
Yeah, Carl, did you want to say something? Carl Landolina, did you have?
Yes, I have some comments and some questions based upon what I've heard thus far.
Okay.
My first comment would be about some of what Tom Clark presented. He talked about some settlement discussions which apparently took place prior to the previous meeting, and I don't know if he said anything about whether those were ongoing or not, but generally speaking, when the issue of settlement discussions are brought into a matter, lawyers get a little nervous. Generally speaking, settlement discussions are not intended to be evidence in any proceeding. So I don't think they're, I wouldn't say they're not relevant, but I think they'd be immaterial at this point to your consideration. So the fact that there was settlement discussions between two property owners is not something that this commission should focus on. One of the comments by, I believe, Attorney Famigletti was based upon a comment made, I understand, at the Planning Commission level when one of the members apparently said something about spot zoning. And this is something, I know you've heard this before, as a member of any zoning commission, you always hear about spot zoning, and it's, I'd say, 1 out of 100 times an actual matter of spot zoning. I don't believe this to be such a case. Spot zoning typically occurs when a very small parcel of land is rezoned out of context or out of harmony with the general character of the neighborhood. It's my understanding that, as you know, most of Summers is actually located in an A1 zone, and the A zone is fairly sparse throughout town. This happens to be one area where there is some A zone property, but rezoning this 9 acres, which in and of itself is probably not, would be considered a small parcel. I'm sorry, the 5 acres would be rezoned. I don't think that would be considered a small enough parcel. It would be spot zoning, but even if it were, it's being attached to a very large area, thousands of acres of continuous A1 zone property, so I don't see a spot zoning issue here. One of the things I'd like to ask Attorney Famigletti and Attorney Merriam about is their opinion on, because right now there's 2 access points to the property, one along this easement way near the Clark's property off of Mountain Road, and the other one would be the driveway of the property leading into Halley Lane. And if you look at one of the sections that Attorney...
We're having trouble hearing you, Carl, as you turn away from
I'm sorry, yep, 21469, subsection E, which is relied upon by Attorney Famigletti, which says proposed truck routes, access and egress to and from the property must be at least 100 feet from side and rear lot lines. Does that mean that the driveway leading into the residential property off of Halley Lane would also be off limits for use by the applicant?
Carl Walton, for the record, I believe Dwight made that point earlier. I did. You only got 175, we measured the frontage, we looked at the assessor's maps, and if you go up Halley Lane, the curved frontage of the Eastman residential lot, and maybe, I don't know, Jay, if you got one of those there that they could see, even with the long curve, that's only 175 feet. You can't get 100 feet on each side. Okay, you see that curve there, and in fact, you can, if it was enlarged, you'd be able to see that the dimension is on there. Let's see if my recollection is, I hope it's correct, I'm pretty sure it's 175 feet. So there's nowhere on that frontage that you could get it. You couldn't get
if I'm sorry to interrupt, Dwight, but
yeah.
as we enter the property from Halley Lane, it sort of goes up and then takes a turn to the left.
Yeah.
Okay, move your cursor up a little bit. Up.
Yep.
Oh, back. What's the distance between there and that property line, the nearest property line?
Oh, I didn't look at that. It's
No, I'm asking, I don't know if Jay's available.
Jay could probably, eyeball it, but, yeah, it's closer than,
It's gone.
So I don't know if Dory has a comment about that. Would the use of the driveway also, be prohibited under 214-69E?
Can you?
Carl, Jay Ersry, I could answer the question there with regard to the driveway location at that point. It is less than 100 feet. However, at that location, we are adjacent to the Schlefstein's property, and we have an agreement, a signed agreement with them, which allows us to go within 10 feet of the property line. So I guess that probably wouldn't be an issue in terms of the location of the driveway. But Dwight is correct in that the total frontage at Halley Lane along the roadway is 175 feet, which is the minimum requirement in your zoning regulations for frontage on residential lots in both the A and A1 zone.
Okay.
Carl, did you want me to respond to that?
Yeah, I mean, I'd like to hear your view on that as well.
Well, I'll go along with what Jay's saying. If the regulations do not allow for the 100 feet setback of the access drive from side lot lines, if they use the existing driveway or any access point on Halley Lane, then and that's possible. It's possible the regulations might prohibit that as well. But the recourse there then is to seek a variance, not to just disregard the regulation. This commission doesn't have the authority to just disregard the regulation. They're bound by their regulations.
Well, there seems to be I understand your argument about McKenzie, but there seems to be an internal consistency between the language of 214-69E and the language of 270-10A and B. How would you reconcile those two sections? One says you can't have it, and the other one seems to imply that in a specific set of circumstances, you may be allowed to have an access point less than 100 feet from side and rear lines. Obviously, we're not talking about frontage lines because, otherwise, because every street, if you get from the street, as soon as I leave the street, I'd be in violation of the regulation because I'd be within 100 feet of somebody's property line.
Yeah, I hear you that conceptually you need to be able to allow access, and access actually has to be obviously coming from a property line, so you're going to have to work on something there. And in section 70C10, there it talks about, now 70C10 again is a separate section from 69E. So 70C10 does talk about allowing activity with the consent of the neighbors within 100 feet of a property line.
Right.
So it does allow for consent of neighbors for activity within 100 feet of a property line. And then it allows the commission that modification to allow for the buffer to cross, the access drive to cross the buffer. I think you can read this, if you want to read it consistently with 69E, you could say 69E says you can't do it within 100 feet of a side or rear. You could read this to say, obviously you can have it within 100 foot of a front property line, and you can have your buffer, just do it in the shortest, quickest way to get there, so you're having as little of an impact on that 100-foot buffer as possible. You could try and reconcile them that way. But I don't know how you can have this section contradicts the very express terms of 69E, which doesn't allow for any wiggle room.
Dwight, do you have any comment how to reconcile the two?
No, I don't think you have to reconcile them for a number of reasons. Number one is that these regulations, and this has been the source of the battle between the Eastmans and the town, are directed to commercial operations. There has never been a single case, never a single case in Summers where a private property owner was required to get this permit for over 1,000 yards. We've asked for them. No one can identify one. We've got affidavits from Jay Osery and from Patricia Carson of many, many instances. So that's the basis of all the litigation, first of all. Second, this is not a quarrying operation. This whole issue of constructing a new road, and this road's not a new road, it's a non-conforming use of some type. It's been there for more than 11 years. It's been used on and off for 3 years for this very operation, is for long-term commercial quarry operations where this commission ought to be concerned about the separation of the driveway access from surrounding properties. Not for 30 days. 30 working days is what we're asking for. And this commission has the broadest discretion. You know, the one thing that Attorney Famiglietti has so wrong is the notion that this provision that I read to you is a kind of illegal variance. That's what she said. I just looked. There are 220 spots in your zoning ordinance where your regulations use the word may and give you discretion. Just think of the one that we had when we talked about Hillsdale, that the commission has the discretion to allow two principal uses on the same lot. May. That's not a variance. That's the broad discretion granted. You can argue about, we as lawyers, we as the three land use lawyers, can throw John Parks in here too, can argue all day long about how many angels dance on the head of a pin over this issue. But these regulations are really intended for commercial quarry operations. And we're struggling to put the Eastmans in that box at this point, and it doesn't work. So we need 30 days, existing road. The commission has the broad discretion to allow crossing of a buffer, and this is a kind of buffer. So I don't think you have to reconcile at all. I think the commission has the broad discretion under that provision to decide which access point that they can go through. And I was just, because we're on the subject of quarrying and commercial use, I just want everybody who's here to know this idea that when Attorney Famiglietti said that they were thumbing their nose, and then Mr. Soares repeated that, but as civilly as he could tonight, and I appreciate that, it is that they have always sincerely believed that they didn't need a permit. Now they stopped. They stopped all work on the site on July 8th. And they told us to go forward and meet every requirement of the town. And they shouldn't be punished for the town's anger over their continuing to work under a cease and desist order when they sincerely believed that they didn't need to have a permit for it. That's behind us. Don't punish them for what you think they shouldn't have done in the past. This is not a hardship case. That's what Patricia Bannock was saying. It's not about hardship. It's about compliance with the regulations. They comply with the regulations, and they should be allowed to use the existing access road for 30 working days under that very broad discretion which the commission has throughout the zoning ordinance. And that's, Madam Chair, that's half of my rebuttal, so you only got half more to listen to.
That's good, because we only got about 15 more minutes. I'm gonna kill this meeting at 9:30.
Let me finish my comments, and just so it's clear on the record, I mean, it's very clear, and people have testified that this has been going on for some time. We have Dwight's comments about the context in which this is going on, and so on and so forth. But as the town attorney, I was asked by the zoning enforcement officer, going back probably 8, 9 months, maybe slightly longer, to look into the activity. I believe that the issuance of the cease and desist orders were proper and they were validly issued. Matter of fact, we issued 2 sets because there may have been a service problem with one of the first sets. I think Amy Eastman's name was miscorrectly spelled, but notwithstanding that, it's been, I think, my office's goal, based upon direction from the zoning enforcement officer, to accomplish 2 things. Number 1 is to get the activity to stop. And number 2 is to bring the Eastmans to the table with applications. Now, maybe it took longer than I would have liked, we all would have liked. Some of that was beyond our control with the court system. But, in terms of what I was engaged to do, I think we've done that. And I would agree with Dwight that, it's only human nature for people to say, well, this has been going on for so long without a permit, that should be a major consideration. I don't think it should be really any consideration. It's only human nature, I think, for you to have that in the back of your mind, but this application has to be judged upon its merits in that context. Is an application, first of all, we've discussed this before, special permit uses are uses that are expressly permitted in the zone. All right? And the only difference between a special permit and a site plan use, beyond the fact that you get a public hearing automatically, is that you can, with special permits, all right, establish conditions of approval which are there to mitigate any of the adverse impacts of the activity. And only if you cannot place reasonable conditions on the activity so as to mitigate the impacts, then and only then are you really justified in turning this down. Now, I'll leave that to you as to whether or not that's occurred, or there are adverse impacts that can't be mitigated by conditions of approval. That's entirely up to you. That's not my role. So that's, something that you're going to have to discuss when you go towards your deliberations. The issue of, since there's litigation pending about the fact that the ZBA turned down 2 variance requests and 2 requests to overturn the cease and desist orders, I'm going to be very careful how I phrase the next thing, but if the activity is expressly permitted, at least for one of these applications as it sits now, subject to conditions to alleviate concerns, and there's no way that the activity can go on because there's a section of the regulations which may or may not, depending on how you read them, prohibit access to the property for this intended purpose, then to me that would be a classic hardship argument. I guess that's the only comments that I have. Of course, the problem with variance is that you don't get to dictate conditions of approval. That leaves the job to somebody else. But that'll be up to you to determine. I think there's got to be a way that these 2 sections can be reconciled. That's as a job as a zoning attorney who represents the commission who drafted these regulations. You have to look at them as a whole and say they are intended to be, and it's our position that they are, first of all, to be read as a whole and consistent with each other, and to find internal inconsistencies that can't be reconciled is not something that a town attorney likes to do when it comes to regulations that this board has written. So in my mind, there's got to be a way to reconcile the 2 sections. So with that, I guess I'll turn it back over to Dwight, and so he can finish his rebuttal, and then we can discuss where to go from here.
If I could, Carl Walton for the record, Attorney Landolina. Are you saying that I'm trying to wrap my head around what you just said about the two issues. What are the two issues that you were talking about?
Well, Attorney Famigletti pointed out in one section, it says that the access road, proposed truck routes, I think, in 21469, it says proposed truck routes. Access and egress to and from the property must be at least 100 feet from the side and rear lot lines. Now, it doesn't say from which side and rear lot lines. Are they talking about the property that we're involved in or neighboring properties? It's not clear as to how that's intended to read. And then you've got the section 2147010B that says notwithstanding the foregoing provisions, i.e. everything else that appeared before, the commission may allow driveways and access points to cross into the buffer areas. Those buffer areas would be, in my mind, based upon everything I read, the land between 100 feet of the rear and side lot lines. Those are the only buffers that's discussed in this section. It doesn't talk about any other real buffers, so I think it would be certainly reasonable to say that's what that section is intended to say, that you can cross into the buffer with a road or access way that's less than 28 feet wide, even if it's not 100 feet from the rear or side lot lines. So, maybe they don't need to be reconciled. Maybe one is clearly there to say, under certain circumstances, you can ignore the other one. And I think that's the applicant's, not ignored, but you may decide that it's more appropriate to use one access point over another. And of course, I would agree with Dwight to some extent that this whole thing is set up when I'm taking a piece of land and I'm going to start this operation and I'm going to build my road, my access point anywhere I want, and I can direct where it's going to be. Obviously, in this context, that's not going to happen. We've got 2 points of access, and I guess it would be up to the commission to decide which one of them is most appropriate under the circumstances. And you've heard evidence, I guess, about sightlines on one versus sightlines on the other. That might have been contradictory. I frankly didn't hear all of Mr. Figler's testimony. I had a personal call I had to take for a second, but I think he was going towards telling you that the sightlines on Halley Lane aren't that good either. But I could be mistaken about that. So anyway, does that answer your question, Carl?
Yeah, it does. Thank you. Did you hear me? Yeah. Okay.
Yes, you're welcome.
No, I couldn't. It didn't light up, so I didn't know if I actually registered.
Usually stuff lights up when I talk. I don't know why this isn't working.
No, that's not what I meant.
I know what you meant.
I have, somebody has their hand up. Patricia?
That was from previous, thank you.
Okay, thank you. I think who lowers it? Do you lower it?
So I don't know if Dwight has any more comments
Just a couple of points, and I don't know whether we have any more information on sightlines at Mountain Road, but my knowledge, I just checked with Dan Eastman, is that there's never been an accident there, people going in and out, and it's comfortable for the operators. The idea that it's a variance, I've already touched on. That provision that I gave you starts with the word notwithstanding, okay? And lawyers know that the word notwithstanding at the beginning of a provision says everything that came before, forget about it. That's why I don't think you have to reconcile it with anything else. And your regulations, as I said, are filled with examples of where you have broad discretion, and you have broad discretion here. The issue of wells and contamination, I'm not a fact witness, I'm a lawyer, but I've known plenty of instances where we've seen dramatic changes in radon and other things in water with no explanation. And so I'd like our professional engineer, Ashley Sullivan, to just spend a couple of minutes, because clearly the neighbors are concerned about a bump up in radon that happened to occur at the same time there's been excavation activity in the neighborhood. So is that right? Is some of this just a perturbation? I don't love that word. Is it?
Sure.
How does that work? And just identify yourself for the record again.
This is Ashley Sullivan with OTO, professional engineer. So I did want to point out, as Dwight mentioned, that radon levels do, just like other contaminants or impacts, do naturally fluctuate over time, both seasonally, over years. For that reason, for most environmental professionals, EPA, OTO will recommend, for instance, in wells, that often to get 2 tests, maybe at least a month apart, and even if they are at lower levels that are below a level of concern, but there is a concern of radon in the area, to even test, again, 3 years, 2 years down the road. So if you don't do a mitigation system, that does not mean you never have to test again. Similarly, for indoor air, we often want a weighted average over seasons, and even if those levels are lower, go back and retest. This is with no external, basically variances, these levels can change even when there's no blasting, no excavation, or really no reason. It's just, and I mean, you can see that the EPA guidance on that to get subsequent testing when mitigation, when you decide you don't need mitigation at that time. I just wanted to state that it is, I mean, we do hold the opinion that radon in uranium, particularly radon in water sources and in air, I mean, there are significant health concerns. So, so we're not disputing that. It's just that these levels can change over time with no known explanation, and that's known.
Okay, thank you, Ashley. This is again Dwight Merriam speaking.
Dwight, Jay Ursary, could I just interrupt quickly for a second? I'd just like to go into the well issue just a little bit more. Again, Jay Ursary with J.R. Russo. Attorney Famiglietti made a very good point in that she suggested that the commission consult with town staff, with the town sanitarian, as to whether or not additional work needed to be done. And I know she came in recently with the Clarks and probably isn't aware that Jen Roy already did consult with the town staff, with Steve Jacobs, and you have a memo from Steve in your packets, which I actually have here, but I'm sure you've all got it. And it was Steve's recommendation, and he actually sent us the draft guidance document from Connecticut Deep with regard to what we have to do in terms of looking at wells within the area of blasting in this excavation. And the thing that it says is all wells within a radius of 500 feet. And we did that. We went and found the wells, got the information from the town. Steve supplied it for us. And we don't have any wells within 500 feet other than the well that's on our own property on the Eastman's land. And if you look at the tests that were done at 39 Long Hill and 47 Long Hill, those are over 1,200 feet away. 24 Amy Lane is over 800 feet away, and the Clark's well is slightly over 500 feet away from the area where this activity has taken place. So I just wanted to bring that point up. I think it was a good point that Attorney Famiglietti made, but in fact, it's already been done, and Steve directed us to this deep guideline, and that's what we've been using in moving forward with the application.
Jay, Jennifer Roy for the record.
What's the date of that memo from Steve?
That was my question.
Memo is dated 1/6/20, and this was based on an original review of Steve that he made of an OTO letter that was dated last November. And what he said basically in his memo was, well, okay, I understand what you're saying with regard to contamination from pollutants from the actual blasting, but he said this area typically can have high concentrations of uranium and radon, and you need to take a look at this. And he sent us the deep guideline, which we have, and that's where it explicitly talks about wells within 500-foot radius of the area, and we don't have any of those. And we've done that, and we've used the guideline, and that's how OTO moved forward, and we're continuing to look at it. But as Ashley has indicated, and Mike Talbot has indicated, we don't think there's an issue with that, and I don't either. Not that it's really my wheelhouse, but based on what we have and the directives that we've gotten from town staff, we think that we've covered this.
Jill Conklin, I'd like to interject here. We've been here for 3 hours, and I don't see this going anywhere quickly. I think we're going to have to continue this.
That's a great idea. Wonderful idea.
Because I still think there's
Can
more...
you hold on a second?
No.
Before you do that, this is Carl Andolina. So, Dwight, are you all set for tonight?
I'm done.
Okay.
I've had my say. I just say that the only other thing was, this is definitely not spot zoning, but you already mentioned that. And I think we've answered all the other questions that we've had from people. We would really like to have this hearing closed and the deliberations done.
Yeah, we would too. This is Jill Conklin speaking. We would like to have this hearing closed and something finalized too, but I think there's still questions possibly. We haven't heard from any of the members of the zoning commission. There's somebody standing in front of me that wants to speak again. I just get a sense that it's not going to end quickly and that we've already been here 3 hours.
Well,
So,
that's obviously up to you, Madam Chairwoman, but, I'm sorry, you said some commission? What commission?
I said the people on the zoning commission haven't even had any questions or responded to anything or chimed in on any, maybe something they want looked at or more information about, or, I'm not speaking for anybody, I'm just talking in general here. I'm falling asleep. Look at my eyes.
Yeah.
I'm tired.
Well, I don't, again, I think you can do what you want, but I think it would be appropriate maybe to poll everybody and see what their feelings are, if they really, and I'm not saying you have to sit here and make a decision tonight. You have time to do that after the hearing closes, but is there any other information that people need or feel they want, beyond what you've heard tonight and last time?
Yes,
and if I might be heard on that, I would suggest, Madam Chair, if it's your commission, and I just made a request, that's all I made was a request.
Miriam, let her talk.
But if you continue it, we would really not like to wait another month. The winter's gonna be coming on, we can't be doing January, February. So we would only ask your indulgence that if you do continue, which we will certainly understand that you may need to, that you continue it to a special meeting, that's all.
I think Jill Conklin, for the record, I think what we should do is, like our attorney advised us, we should probably poll the committee and see if people feel there's additional information. I would like to, personally, I would like to know, because I know when people buy houses, they get water tests. I would like to know what some of the other tests were. We saw one example of a before and after, or a difference in a range, but, maybe someone has a test from 3 years ago, or 5 years ago.
Chairwoman, sorry.
Yes, Lucas, for interrupting me.
Cherry, for the record, Ms. Chairwoman. I had testing done, and I'd be happy to submit that.
You had testing done?
Not related to this, but just showing uranium is in, water.
Okay, but you're like on Main Street, so that's got nothing to do with this application.
No, absolutely, but people saying that there's a natural occurrence, it backs up I believe, the engineer's report, indicating that uranium is a natural occurring,
If I may, Madam Chairwoman, is there any doubt in any of the commissioners' mind that radon and uranium occur naturally in summers and
none at all.
Water?
I have no doubt.
Okay.
I think what you're discussing, Madam Chairwoman, you want other people in the neighborhood to get their wells retested and get that
I'm gonna log off here because my battery is dying, so I'm gonna join Jen, but I have to log off, sorry. I'm not gonna let this, I'm leaving the meeting. I'll leave. I just have to close this down. I don't wanna have a bad close. I didn't know I'd need a full battery for this, but. Okay.
For the record, this is Paige Rassid.
Hi, Paige.
Madam, hi there. I would like to mention to continue this public hearing. I see people queued up to speak still after all this time. Perhaps Jen Roy could look and see what the next possible date for the next meeting on this could possibly be.
I know
And I'd be happy to make a motion to
continue.
continue this.
The attorneys want a special.
If I may interrupt while
meeting.
Jen's looking for a date, obviously that's within your purview. I would suggest that you make an announcement, because if everyone just keeps restating the same things at the next meeting, well, we're going to get back to a 3-hour meeting.
No, we're not.
You know, my client's going to arrive, so I think you need to tell people.
Yeah.
And that includes the applicant. I only want to hear new stuff.
Yeah.
Got everything you've told me so far. I only want to hear new stuff, okay? Because we've heard 2 nights of basically the same material. I think it's relevant material. It's something that you should be, you know, considering in your deliberations for the most part. But, you know, again, we're going to have the same conversation whenever this next meeting is at 9:34 when we hit the 3-hour mark.
We're not gonna have it, because I'm not gonna let it happen. I won't let him speak.
Chairwoman, could we consider, as you recommended, Lucas, chair for the record, and as our town attorney recommended, doing the polling?
Yeah, but,
You can still talk.
go ahead, take the poll, somebody take the poll. I mean, I can't really see the screen because we're looking at a date here, but,
Well, you know, actually, there is a motion on the table by Paige, so,
Paige
Has not
made
been seconded.
yeah,
Wait.
yeah. So she
All right,
can withdraw
with
or
everybody
ask for a
talking
second
at once,
as soon as we get a date from Jen.
Can you see me?
Yeah, we see you.
If
So-
that motion's withdrawn, you can page the commission and find out what they want to do. Or if it's not seconded,
Paige,
voted on.
Paige.
Yes, Jen, I'm here.
Paige, it's Jill. I'm coming through Jen's computer because my battery died. Do you want to withdraw that and we can poll, or because it'd be nice to know what people want a little bit. I'd rather spend a minute or two finding out.
Well,
In terms of whether to continue or to close and make a decision, or at least close the public hearing?
No, I would like to know if there's, if we think we need more information and maybe what that information might be, so we can be prepared at our next meeting. And then decide if we want, I mean, I'm not ready to close, I'll pull right here, but I know we have a motion on the table for you to continue this. So if you want to remove that for a minute, I'm not telling you to, but if you do, then we can take it.
Yeah, sure, I'll rescind that.
Thank you. So now we can talk about what we might want from added information, or if you want to do a poll first, who's ready? Who's ready to, who would like to keep it open? Paige, would you like to keep it open?
Paige Rassid, yes.
Okay, Carl Walton?
yes, I would like to keep it open.
Yes. Dan Ferrero? You gotta unmute yourself, Dan.
Uh-oh.
Dan, put your hand up if you want to keep it open. Okay, Dan put his hand up.
Put your hand down,
Lucas,
Okay, I would like to keep it open, but for new material.
new material, yes, only, exactly, yeah,
Only new material.
new material. How about Lucas?
I support closing it unless someone that has not already provided information or new information is provided. But, you know, again, I could talk to myself literally for the next 25 years on this topic. I just don't, we need new information or we need
Okay.
information from
So-
other parties, but,
So I don't want to cut
really
you
don't wanna
off,
listen
but
to
I'm
things,
going to.
so.
I'm going to cut you off, Lucas, just because the majority of the, commission said they'd like to keep it open. So someone can make a motion to keep this open, but still, I want to know if there's,
2 weeks from now, or 3 weeks?
if there's anybody on the commission that has something they want to know, something we don't have, something we need to know, something
Carl
we
Wall,
need to look
for the
into.
I have two questions. One, 42 Halley Lane is A-zoned currently, correct?
Correct. Yeah.
Where is 42 Halley Lane's frontage as a lot? Second is...
Say again, I'm sorry, say again. 42 Alley Lane is a zone.
Yep.
What, and the question?
Where's its frontage? On what road, where?
Frontage, okay.
Ask Jay Ursery if he's still here.
And two, what's the best reason you have for why we should consider changing it from A to A1, other than they can't do it if we don't?
Because that's the big issue. Without that, the other two are, that's the big issue.
And I might add, after looking at the map, what is the purpose of leaving such an oddly shaped A1 piece sort of now as an island off nowhere?
Do you mean
I can
A?
answer that.
Go ahead.
42 Halley Lane is under Public Act 490 for conservation land, and we thought it would be best for the neighbors if we limited the rezoning area to the absolute minimum necessary to remove the rock, thereby preserving the conservation restrictions on the balance of the property. We could have done all 9 acres, but we did 9 acres in order to avoid fragments of lot being shown and minimized it to just the rock outcrop. But it is an extension of 40s, that's why it's not spot zoning either.
Carl Walton for the record. There was a map that you showed earlier, Jay, that in what I can see now better defined what was remaining as A1 or A after the conversion to A1 of the land added. I don't know if that's it or not. Now the text box is too big in the way.
Bear with me here for a second, Carl. Let me get back to the share screen here. Okay, so this is the actual zone change map. And again, Jay Ursery for the record. The 5.45 acres of the area to be
The area cross-hatched?
It's the cross-hatched area. It's an extension of the A1 zone that's currently part of 40. These are combined lots now, so it's just an extension of this zone, which we create one larger A1 parcel, residential parcel. The remaining land here that Dwight is talking about will remain in the A zone. As he said, it's in 490, and that's the reason for trying to limit the amount of land that we take out, because
What is left of?
it's over 30 acres. It's over 30 acres remaining.
It's 33 and change, because it was 42 before.
It's kind of a moot point. It just seems odd to me to leave an odd-shaped piece of land in the middle of nowhere.
Well, we wouldn't characterize it as, this is Dwight Merriam, we wouldn't characterize it as odd-shaped. And incidentally, I just consulted with Dan Eastman. He says, actually, there's no frontage for 42. It has no frontage. It's the rear of 40.
And, Lucas.
It's the rear of 40.
Sherry, for the record, for Carl Walton, when you say, you're talking, the hatch area? Because I see, nothing's a perfect, square or rectangle,
Lucas,
number 4.
just for clarification, Lucas, no, I'm not talking about this. The crosshatched area actually is a pretty logical space.
Okay.
What I'm talking about is the space to the right of that, which is also part of their land.
Yep.
Which now is a different designation as far as the zoning designation, because it's zoned A.
Yeah.
And now it's kind of landlocked.
Yeah, Jay,
From a logical, radical planning perspective, it seems illogical to leave a piece like that.
Okay, I see what
That's my question, that was all.
And then the one right beneath the one that Jay is moving his cursor around on,
That's the area that Carl's talking about.
Right where he is, right there is what I'm talking
Right
about.
where the cursor is now, and Dwight's response was that it's in a classification of 490 or open space with the tax assessor, and there's a tax break on it, and if we change it...
There won't be a tax break, right.
Yeah, okay.
Correct, that's the reason.
Yeah.
This is Paige Rassid for the record. I would like to make a motion to continue this public hearing to a date that Jen Roy is yet to suggest.
Jennifer Roy for
I
the
would second
record. Jennifer Roy for the record, Paige, was waiting for my chance to speak. The calendar is open for the next couple of weeks. Well, next Monday is Labor Day, but then the week after, week of the 14th, week of the 21st.
I mean, it doesn't have to be a Monday.
Well, Tuesday's wide open.
Tuesday's
they
wide
don't meet
open.
in the auditorium.
Yeah.
So, depending on how many weeks you want to go out.
I will make a motion to continue this public hearing until a special meeting on September 14th, Monday at 6:30.
14th?
Correct.
Really?
None of
these meet here?
committees
You gotta-
meet here.
Okay, another Monday. Okay, the 14th.
Not the 14th? Or is the 14th open?
Yes, it is. So, Carl Walton, you seconded her motion?
I will second the
Thanks
motion
for
for the
running it
meeting
for
to be
me.
extended until the 14th.
Okay, so Paige made a motion, Carl seconded it, to continue this public hearing until September 14th at 6:30 here in the town hall. All in favor? Aye.
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 Okay, so we are continuing.
Carl Landell, sorry.
No,
So
Yeah,
I guess I'm gonna say if any of the commission members want any more additional information, we can let Jen know, right? And you can.
Well, I don't know if we can't take any information unless it's from a request from the public hearing, I don't believe, correct?
We can't request something that we may want, like,
You could take in new
I don't
information
know, I
at the
can't
public
think right
hearing,
now.
correct, Carl?
Yes,
Angelina?
absolutely, that's the
Right,
purpose
yeah,
of
that's what
continuing the
keeping it
public
open,
hearing, is
yeah,
to take
right.
new information,
So during the public hearing on the
something
14th.
that you have a burning desire to know about between now and the 14th, and I would suggest that you let Jen know, and sooner than later, and so she can get that information from the applicant.
Good.
And if you wanted, for instance, Steve and, Jeff, to look at, the new OTO letter or anything else, that's, you know, that their comments would be, relevant on as to groundwater protection, that kind of thing, you know, you could do that as well in the interim.
Perfect. So we're gonna go continue our meeting, so anyone that doesn't wanna be here for the continuance, we have a couple more things on our agenda. I'm gonna move right forward here. Moving right down to old business discussion these are for the three, public hearings we just had, those are gonna be tabled. Moving on to a new business, it looks like that was withdrawn, was it?
Correct, I received an email from the applicant, Sarah Christie.
Okay.
Jennifer Roy for the record, she's withdrawn application number 20-012.
So that's been withdrawn. Moving down to correspondence, we have one correspondent. We have, we had a correspondent from Attorney John Parks regarding the Union Agricultural Society of Summers, Enfield, Ellington, and East Windsor. This, as you may recall, this was before us quite a while ago, and the application was withdrawn. So I don't think we need to discuss anything on this because we don't have an application before us. But Jennifer, I want you to make sure everybody gets a copy of that.
They should have already received, but I will email it again
Okay.
if you'd like.
Yep. So with that said, we got minutes approval. We can either do that or we can table those.
Paige Rassett, for the record, can we table that till next meeting?
Do I have a second? Is that a motion?
Yes.
Yes, second that, somebody?
I'll second Dan Farrell.
Dan, second that. Any discussion, because I know people are waiting on our
Were
minutes.
there a lot of issues with the minutes other than Mr. Fiegler wanting to be included in the list of people who spoke, which I think is appropriate?
Jennifer Roy, for the record, that would be the only issue that I was made aware of would be adding his name to the list of those speaking in opposition.
I would make
August 3rd.
a motion to amend the minutes. The addition of Joseph Fiegler, his street address
I think you would need
Mountain
to,
Road
I think
being
you-
added.
Carl, I think you would need to, Paige made a motion to table the minutes.
I know,
And
we didn't
Dan,
vote on it. Oh,
Dan
okay,
seconded.
sorry, discussion.
Discussion.
It's discussion,
It's
so,
late, it's late.
I know, it is late, so.
so you have to vote on tabling them. We can't, and then we would just amend them.
We can vote
at-
against tabling them and go back.
I thought it was just discussion.
Well, when we got a second motion, I said, any discussion?
All in favor of tabling?
Because we do have that issue with people are like chomping at the bit for our minutes.
Right.
Stuff comes out of my mouth when it's this way. So,
There's a
However,
motion on the
however-
table?
there's a motion on,
However, it's gotta go.
Just vote on the motion.
vote on the motion.
Table.
To table the minutes.
Aye.
Dan
Dan
wants,
Farrell.
Dan's tabling the minutes. Paige,
Yeah, table the minutes.
table.
Paige.
Carl,
Sure, why not?
sure. Lucas?
Sure, yeah.
Okay. I agree, unanimous. We'll table the minutes and, make a motion to adjourn.
Paige Rassett making that motion.
Paige
I wanna,
Massey?
let's just stay, come on.
No, Paige made a motion to adjourn. Let's see if we can get a second. Do we have a second?
Dan Farrell seconds it.
Dan Farrell steps up to the table and seconds the motion.
Discussion?
Any discussion? Absolutely not. All in favor, raise your hand, or aye?
Aye.
Aye.
I might raise my hand
Okay,
too.
so, closing the meeting at 9:50. The things we do.
Good night,
Good
everyone.
night.
Good night. Sure, no problem. It should work every time now.